Good morning, everybody. Happy Friday. Welcome to the Courtroom Files Live. Let's start today in Miami-Dade. This is Judge Glazer.
Corey,
She currently resides at Camilla's house, Judge.
Okay,
If you would
we'll tap
consider-
taker.
Would you consider an ROR with a future court date, Judge? We'll give her the court date now.
so I don't see any criminal history on her. I don't know if she's just going through.
How long have you lived in Miami, ma'am?
Not long. I came here for my husband got Baker acted, and I've been here since.
Okay, you are ordered to stay away from the 7-Eleven store at 735 Northwest 12th Avenue in Miami, Florida. You're not allowed to go to that 7-Eleven and you must stay away from there. Do you understand?
Yes, ma'am.
Okay, you want me to ROR her with a date certain?
Yeah, let's know when she has to come to court.
I need 30 days from today, please.
8/8 here.
Today's 8/8.
9/8.
So you have to come to court for your arraignment on 9/8 at 9 a.m. Courtroom 443, Judge Carbarga.
Right, it's kind of by Camilla's house.
All right. Have a nice day. Next case.
Counts, Your Honor.
ROR count 1 and ROR count 2. Thank you, but there's probable cause for count 1 petty theft, M2, and count 2 there's probable cause. Catherine Gilmore is next, page 1. Good morning, Miss Gilmore. You were arrested for attempted second-degree murder. This is a case from June 29th of 2025. I will appoint the public defender's office for you. So I need a review.
It should be attempted second-degree murder with a deadly weapon, to wit, a knife.
A knife. Victim had a stab wound to the right side of his neck. And she's the wife, the victim's wife.
She was shot as well.
Judge, for the record, we're going to be invoking Ms. Gilmore's right to counsel and her right to remain silent. Looks like she was attacked first by her husband.
So I guess she used a butcher knife. He used the gun. Ma'am, I'm entering a stay. First of all, have you been living in the house or who's living in the house?
It's me and my cousin. He helped me with my wound.
Miss Corey, is she staying in the house?
She's staying in the house. He is not. This is an incident from June 29th.
I know. All right. So
Hospitalized for about 2 weeks.
ma'am, all right, so stay away from the alleged victim whose initials are DG, your husband, no contact with him either directly, indirectly, in person, in writing, by telephone or through third parties, no contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the victim, his home and school and place of employment at all times. Do not engage in any criminal activity, do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, ma'am?
Ma'am.
All right, so the state
I would
filed,
ask if you would
yes,
consider setting a bond for Ms. Gilmore.
I can't do that. I understand you got to go see the division judge. I'm so sorry. I based on the allegations. Unless the state had no objection.
At this point, the state is requesting that the defendant be held pending the motion.
I'm going to grant the state's motion for
Judge, she has a nurse at home that cares for her. She was shot multiple times.
Where was she?
After she stabbed him in the neck, and the wound was millimeters away from hitting a major artery.
He's not in treatment. She's still getting treatment for her gunshot
She
wound.
got arrested at home.
I got shot.
She was arrested at her house. You want me, I can do house arrest.
The state's requesting
Yeah,
that.
Judge,
mean,
I would ask if you do house arrest, Judge.
These are unusual circumstances. Who's her nurse? You got a family member who's a nurse?
When I went home, the hospital appointed me a nurse, a home care nurse.
Oh, they come home? All right.
Yeah.
And he's not in a home, right?
No, ma'am, he don't stay with me. We not together no more.
That's a good thing.
My cousin stayed there and he helped me take care of my wounds and the nurse come. I have to wait 3 days. I got an open wounds in my stomach. My stomach is open.
How many times were you shot?
I
Was
was
it
shot,
4?
I was shot 5 times. 1 in my leg, in my vagina, my stomach, my butt.
I'm sorry to hear that, ma'am. All right, so I'll give her house arrest with a GPS monitor. Alternate bond will be no bond.
It is over state's objection.
All right, so for today, I'm denying the state's motion for pretrial detention is denied, and I'll do level 3 house arrest. The division judge can revisit the state's motion for pretrial detention at any time. Can corrections do anything to expedite her? It sounds like she needs her medical care.
So good morning once again, everybody. Welcome to the Courtroom Files Live. I can guarantee you what we just heard is a first for this channel. So there you go. You never know what you're going to hear at TCF. Let's go to Judge Simpson. He's just getting his day started. Sounds like he's doing a final settlement docket.
Updates to this case have come out, and at this point, the defendant is in custody for failing to appear at a PTO violation here up in circuit court. There's also a new case that will be upcoming and will be charged today for an FA that occurred on July 26th. So in this case, I'll be asking for an adjournment to the October dates, as well as the defendant's bond being denied in this case for the bond violation that is upcoming for the FA.
Your Honor, no objection to the adjournment to the October final settlement conference date. Regarding bond, I'd ask that the court keep his bond as it is. As the court knows, this case hasn't been charged out yet. He hasn't been arraigned on it. If he's going to be held on that case, a magistrate will make that decision when he is arraigned.
What I will do is I will adjourn the jury final settlement conference and jury selection to October 17th, 2025, 9 a.m. for the settlement conference, and jury selection, if necessary, October 20th, 2025 at 8:30. Given the circumstances, what I will do at this point is I will revoke the defendant's bond. And that's based upon the representations pending a hearing on the violation. If you'd like me to set that, then you just let the court know. We will set a violation here. Okay. All right. So ideally, the best thing is to set it after the arraignment. Sure.
So while he's between contestants, thank you to Barbara for donating the 1 membership, and thank you to Lindsay for just donating 5, getting things off to a fast start here for this Friday. Thank you so much, guys. Appreciate it.
Yeah, the people, Your Honor.
They weren't ready.
How's it going,
I
Judge?
just want Bird and Matt to wait. Bond Sanders. I'm just letting you know how I feel.
Good morning, Public Defender Lauren Perny on behalf of Mr. Bond Sanders. State your name for the record, please.
Your Bond Sanders.
Your Honor, we have come to a resolution. Mr. Bond Sanders is going to plead as charged in this case. This was part of a global resolution that included some felony charges that were up 2 weeks ago at exam. Those felony charges were dismissed and he pled it on a DV there.
And that's correct, Your Honor. That file is coming before Your Honor. I believe that sentencing was adjourned. After the plea in this case, though, Your Honor, the victim is here to request contact. I'm not sure if the court will get on the other file. It's still no contact as well. I'm not sure if the court has that file.
I do not have that file with me. Sorry.
Yeah, it's scheduled for the 18th. Did you say that? Sorry. The sentencing on the first DV is scheduled for the 18th. I assume Ms. Pilara is going to.
I'm going to let her take a look at all of that before I even make a ruling on contact on this, just to let you know. I'm going to see my phone. All right.
Yeah. Your Honor, sorry, before we enter the plea, Mr. Bond Sanders is asking if you'd consider entering or giving him back his phone privileges. They were revoked. I couldn't give you a date, but several weeks ago, given the representations made by the people.
That's correct, Your Honor. He was contacting the victim from custody. That's why they were revoked.
Correct. And which was a violation of his bond. I am not inclined to reinstate those phone privileges at this point. Given that everything is coming up, I will take a look at everything come the 18th. Fine. But may I have him sworn?
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give the truth, the whole truth, and nothing but the truth, so you got it? Lower and then say your name again.
Azor Bond Sanders.
Sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of June 27, 2025, at the location of 2265 Glencoe Hills Drive, Apartment 5, Pittsfield Township, Washtenaw County, State of Michigan, what did you do regarding, is it Natalisha
Tisha.
Henderson that makes you think that you're guilty?
I threw sand at her.
Pardon?
I threw sand at her.
You threw sand at her, so you
Yes.
threw something at her?
Yes.
Okay, and who is she to you?
That's the mother of my son.
Okay, so you have a child in common?
Yes.
All right. And you didn't have her permission to do that, did you?
Uh,
All right. And you did it intentionally?
yes.
All right. If I accept your plea and you commit misconduct between now and the time of sentencing as defined by the Michigan court rules, any sentence agreement or evaluation, the court is no longer bound by, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or inducements which have caused this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule?
Yes, Your Honor.
Yes.
All right. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation, pre-sentence investigation, and report. He is set for sentencing on that other case on the 18th.
Yes.
Is it?
That's correct.
We can do the 18th.
Okay.
Pardon? Yeah. Sentencing in this matter will be August 18th, 2025 at 1 p.m. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you.
Right? Thank you.
So Ashley, thank you for the 10 memberships that you just gifted. Incredibly kind of you. Michael, I'm a little bit disappointed. I watched your video yesterday and you said nothing about rain on Friday, but it is clearly raining. So thank all of you who are helping with that. We are averaging 1 new member a minute so far today. So it's wonderful. Thanks so much.
People being unable to proceed, this case is dismissed. That's without prejudice.
Your Honor, request that the court check the box returning prints and arrest
I
data.
don't have the. I don't have a dismissal.
Okay, I can prepare one for the court. Thank you.
Court calls the case, People versus Robin Muhammad. Oh, they just called for him.
Alexander, on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Muhammad.
He's coming out. I may have called it a bit early. Weidling, why was he up there trying to talk to you?
Mr. Simon?
No,
He always talks.
No, this one.
I'll talk to yeah.
Don't talk to him. You can talk to Joe. Talk to him. Ramin Muhammad. He just came up there. He looked like he was up to something.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Muhammad. State your name for the record, please, sir.
Rahman Muhammad.
Thank you.
Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you.
Thank you.
Thank you.
Court calls the case, People versus Tierra Peterson.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Tina Sachs on behalf of Ms. Peterson's son.
What?
Son.
Son?
Unfortunately, she wasn't able to secure
She was what?
childcare. She wasn't able to secure childcare. We know this is a dismissal.
Want me to punish her for bringing a baby?
Absolutely not. He's
Oh,
Julie.
all right. I didn't know what you want. How old?
10 months.
10 months? Oh. See, now I can be in a good mood.
That's what I said.
Huh?
I said the same thing.
I know, I'm a sucker for babies. But don't everybody be bringing you,
I was like, I'm always having a baby on my hip for now on.
because some of them don't know how to behave. This is much like my staff. All right.
Your Honor, today's date and time set for final settlement conference. At this time, people are unable to proceed.
Your Honor, defense moves for dismissal.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, sir.
Thank you. Court does call the case, People versus Elizabeth Raggett.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Your Honor. Sam Bernstein with and on behalf of Ms. Raggett. Ms. Raggett, can you please say your name to the court?
Elizabeth Raggett.
She's going to enter a plea
Yes, Your Honor.
to OWI. Is that correct?
Yes, Your Honor.
That's correct.
May I have her sworn?
You solemnly swear or affirm testimony you're about to give the truth, whole truth, and nothing but the truth, help you God.
I do.
Lower your hand and say your name again.
Elizabeth Raggett.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, Your Honor.
Do you still wish to plead guilty?
I do, Your Honor.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do, Your Honor.
All right. You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights?
No.
All right. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
Yes, I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today
No, Your Honor.
to get you to plead to this?
Right.
Sorry.
I understand.
Has anybody threatened you or coerced you?
No,
You're doing this voluntarily?
I am.
Of your own free will?
Yes,
And because you believe that you are indeed guilty of this offense?
I am, Your Honor.
On the date March 27, 2025, at the location of Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
I did.
What did you have and how much?
I had about almost 2 bottles of wine.
All right. Were you stopped by the police or was there an accident?
There was an accident.
What happened?
I pulled out, and I misjudged, and I went directly into another vehicle. It was trying to turn left. I'm really sorry.
The police arrived?
They did.
Were you taken to the hospital?
I was.
And was there a blood test?
There was.
And the blood test was 0.191?
Yes.
All right. Do you have any reason to dispute those blood tests?
No.
Ma'am, you understand that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea and any sentence evaluation or recommendation, the court would not be bound.
I understand, Your Honor.
Counsel, have there been any other promises, threats, or inducements that you're aware of that have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
August 27th at 12.
August 27, 2025, noon. All right.
Could I just bond, Your Honor?
Yes, you may.
Ms. Raggett has, she's been in jail for 3 weeks now. Obviously, tell by her demeanor that candidly she has struggled with alcohol. That's something that she's very well aware of. She knows that she needs help. She had signed up for the Trinity Addiction Services program prior to her incarceration. It was a 3-day-a-week program that would involve counseling and group sessions, and she thinks would be really beneficial for her. We talked about the plea form, and specifically if she were to be given the privilege of release, any sort of drinking behavior would likely result in jail incarceration rather than probation. So she's pretty well aware of that, Your Honor. She has pressing family concerns that she's hoping to get back to in the world, an ill father and a son as well. So she has some responsibility she's very, very eager to, and I can tell she's actually quite ashamed at her behavior, and she's hoping to get help, Your Honor. So she's asking for the chance to be released and prove to the court that she can get herself to that program and follow through on that.
Was she originally on a PR bond?
Yeah, she had bond violations, Your Honor.
Yeah, that's what I thought. But she was on a sober list.
Yes.
All right. And then had the violations. All right. Anything from the people regarding this?
Your Honor, if the court is considering releasing her, if people would request a scram.
When would you get yourself enrolled in the program?
I am enrolled.
You are enrolled?
Yeah, I had an appointment on the 28th and I couldn't attend because I was here, but they're just waiting for me to get out so I can get back.
And that's the Trinity Addiction?
Trinity Health is 3 days a week. Yes, and that also includes testing, Your Honor.
What I'm going to do is I'm going to give you a shot.
Thank you.
It's going to be up to you, though.
Okay.
So I'm going to reduce her bond to a personal cognizance of $25,000 bond. Defendant is to be placed on a scram tether unit prior to her release.
Thank you, Your Honor.
Right? I'll see you at 7.
Thank you.
Right? And Mr. Bernstein is right. That if you violate, it's going to be a jail sentence.
I understand.
Thank you.
Well, hopefully, friends, she makes it, and hopefully this chance that he's giving her works out. Michael, thank you for donating 5 memberships, keeping up our pace to that point of about 1 new member a minute, which is just amazing. I see Slightly Stoned got gifted a membership. Hopefully he's able to remember that he got that. And Miss Jackson no longer needs to be apologized to, I suppose. No longer sorry, Miss Jackson. She has a membership. Let's change it up a little bit. Let's go to Florida. Wade Mercer is back from a couple of days off, and he's doing his first appearances.
Moments. But the 2 attorneys we have right now are Mr. John McDaniel, Assistant Public Defender at the jail. In the courtroom, we have Mr. Gill, prosecutor. I want to make sure you can see and hear him, so I'm going to ask if he introduce himself.
Yes, thank you, Judge Lawrence Gill, on behalf of the state.
Thank you. And Corporal, can you see and hear both of us well at the court, at the jail?
Yes, Your Honor.
Great. First case is Roy Pepples.
Morning, Your Honor.
Mr. Pepples, good morning. Mr. Pepples, you're here for first appearance accused of 1 count of domestic battery. Mr. Pepples, there is probable cause in the charge, in the complaint. It's a case where the officer chose to elect to arrest both people, but I think there's enough there for probable cause. I know there's an issue with the bond, and there's a very new statute at play, or actually it's a rule of procedure at play. Mr. McDaniel, do you want to be heard on whether or not his bond can be revoked at this point?
Your Honor, I would just, I think the statute, or the rule change 34134 is pretty clear. On the 63rd date, if the state hadn't requested an extension, I think his newest case is 70 days old today. So, I've just argued that he should be on an ROR on that charge and that other charge. The question of retroactivity of it, I don't have the Supreme Court case with me, but there's a Supreme Court case that differentiates between procedure changes and law changes, substantive changes versus procedural changes. And generally speaking, procedure changes act on every case that's active. Substantive changes, apply prospectively. I would argue that, he should, those cases there, he's on the ROR at this point in time, and not holding with that bond.
Is it your position it's an ROR without conditions?
Correct.
Is it your position then that the ROR automatically, the conditions automatically go away without any action by the defense?
Correct. I think this is limitations that the Supreme Court's put on the state, because essentially they asked for these changes in the Supreme Court rules, and it was primarily prosecutors that asked them. My, thought process is they basically put other kind of restrictions on there. Ironically, it's going to mostly affect people like Mr. Pebbles, who gets charged multiple times, but I think the Supreme Court is saying if a person is a bad person, then they should be filing something on them, not sitting on them. I think that was the Supreme Court's ideals, on that, to put some kind of restrictions on the state where they got to do something to make sure that the move cases are going to move forward if they're going to move forward.
So here's the question I have. The new rule 3.134B2, subsection 2, which is under the heading of defendants not in custody, says on the expiration of the time period prescribed in subsection 1, which is what you're talking about, and on motion with notice to the state, the court shall order that the defendant be released from all requirements of bail and all conditions of pretrial release unless the defendant has been formally charged with a crime. So that subsection seems to imply to me that even though there may be an ROR, there still can be conditions with it until there's a motion and notice to the state. So my question is he entitled to an ROR, but is this rule distinguishing that from all conditions of release and all conditions of bond? And the reason that's relevant in this case is the jail sheet is wrong in both cases. And in the case he's on bond for 25-270, he's on for a felony DUI. The jail sheet shows no special conditions, which I know that's very unusual. So I went back and watched the video, and Judge Patterson clearly put a condition of no alcohol. So the jail just didn't write it on the first appearance sheet, but the judge clearly said it. And then in case 25-222 CF, which is also on bond for, that's an ag assault, I put a condition of no contact with alleged victim, which is the same person he allegedly was with yesterday. So the jail didn't write it on that sheet either. So Corporal, if you can make, whoever's writing these notes for first appearance, if there's a condition, no contact or no alcohol or any other special condition, it needs to be on the first appearance sheet. So Mr. McDaniel, my question is, two different judges put conditions on bonds, and just because he's entitled to an ROR, does those conditions go away even though he's entitled to the ROR, Mr. McDaniel?
I'll read section B2, Your Honor, and it says, you know, the court shall order that the defendant be released from all requirements of bail and all conditions of pretrial release unless the defendant has been formally charged with a crime. I think it's, you know, when it says all conditions, I think that's.
You're not reading the 6 words before that. On motion with notice to the state. The defense hasn't filed a motion and hasn't been any notice to the state.
Correct. And that motion, you know, the defendants do not have any kind of attorney at this point in time, and the Supreme Court has laid that out as the responsibility of the court to do. And I realize that it's going to be ugly if the court decides, well, we're just not going to do it. And then who gets punished is, you know, the defendants. I mean, this is, you know, the court's supposed to do that on its own, and do these orders.
The court can't file a motion. I don't know that that's the court's responsibility. On the expiration of the time period prescribed in subsection 1 and on motion with notice to the state, the court shall order. So you're saying you think it's the court's responsibility to do that, not the defendant or his counsel?
Correct. It is the court's responsibility.
Mr. Gill.
Judge, I have not reviewed this new change, but from my understanding, so he's on bond in two felony cases?
He was on bond in the felony case. More than 60 days later, there was a new arrest. The first one was felony DUI. No, the first one was ag assault.
Okay.
Then there was a new arrest for felony DUI that was outside of 60 days. At that time, Mr. McDaniel, Mr. Mitchell agreed that it became an ROR because the state didn't file charges. I think there were some questions about the ag assault. Now, another 60 days has passed since the second DUI, and the state still has not filed charges on either case. The first one or the second one, despite there being a breath alcohol level in the second DUI, second charge was the felony DUI. So Mr. McDaniel is saying that automatically, without any motion, without anything filing by anybody, automatically he becomes an ROR, which this rule appears to say, but also that any conditions of the bond go away. And I don't know that I agree with that.
I mean, Judge, I haven't looked at it, but it says that upon filing a motion with the court and notice to the state, I would require that it had to be ruled on by the court by a motion from the defense before that goes away without seeing anything further.
Okay. Anything else, Mr. McDaniel?
Your Honor, I think the rule clearly says that the court files that motion. It's not the defendant. So
where does it say that at? Show me.
And I have to go back to the rule.
Yeah. I got the rule in front of me. I printed it out this morning. I'd love to see that.
So it says rule part number 1, the court on the 60th day and with notice to the state must order the defendant automatically released on their own recognizance on the 63rd day unless the state files formal charges by that date. So, I mean, it clearly says.
Where are you reading at? Are you in subsection A or B?
I'm in B1. It says the last portion of that sentence, the court on the 60th day.
Okay, so let me just read for the record the rule. Defendant's not in custody. This is 3.134B. The state must file formal charges on defendants on pretrial release by information or indictment or in the case of alleged misdemeanors by whatever document constitutes a formal charge within 60 days from the date on which defendants are arrested or from the date of the service of capias on them. If the defendant remains uncharged, the court on the 60th day and with notice to the state must, and under that must, there's an A and a B. A, order that defendant automatically be released on their own recognizance. First of all, that doesn't make sense to me because they're already out. So I'm not sure why the the rule says they're to be automatically released when the heading of the section says not in custody, so they're out, period. So anyway, you keep reading, must be released on their own recognizance on the 63rd day unless the state files formal charges by the state. So that happened because he wasn't in custody. He was already out. So he's released.
Well, I don't think the release is released from jail, Your Honor. I think they're saying release from pretrial conditions.
It doesn't say that. It says release on their own recognizance. Or B, if good cause is shown by the state, the court may continue the defendant on pretrial release for up to an additional 30 days unless the state files formal charges, which they haven't. And then there's a subsection 2, which says on the expiration of the time period prescribed in subsection 1, so on the expiration of the 63 days, and on motion and with notice to the state, the court shall order that the defendant be released from all requirements of bail and conditions of pretrial release, and unless the defendant has been formally charged with the crime. So clearly the state's got to have some notice from somebody, and I know that you're saying it's the court's responsibility to
It's
do
just
that.
like the 40-day rule that we've done, forever, Your Honor. I mean, that's the court's responsibility to do that. And a lot of times, I mean, the PD's
That's not
office-
true at all. It's not accurate, Mr. McDaniel. The defense has to bring that motion forward. It's your job, frankly, to do that in the 40-day rule. Mr. Gill,
And we also have, we can able to show a good cause for the reason for delay too. We have an option to, show a good cause.
yeah. So I'm going to determine that you have violated conditions of your bond in both cases. It's your third arrest in less than 4 months. I'm going to revoke your bond in both 25-222 CF and 25-270 CF based upon the new offense, as well as having contact with the alleged victim, as well as consuming alcohol. So you have no bond in those two cases. You're entitled to a bond, Mr. Pepples, in a new battery charge. Your bond in that case is going to be $25,000 because you keep getting arrested. So you've got a $25,000 bond in one case, no bond in the other two cases, sir, and we'll be seeing an upcoming court date. I'm going to ask Mr. McDaniel to notify, actually, you can't notify your attorney because the state hasn't filed charges yet, so you don't have an attorney appointed. So, Mr. Gill, the state needs to make a decision on what you're going to do on these cases, and please talk with the other felony prosecutor about this rule.
Yes, Your Honor.
Because y'all clearly have a 60-day requirement to do something, and Judge,
Is there also a no contact provision with the cross complainant in that condition of bond on the new law?
yes, that condition is already there with a prior case, but we'll renew it in this case also. Thank you. So, Mr. Pepples, you don't have a bond in those two cases. I'm sure Mr. McDaniel is going to take appropriate action on your behalf, no court has interpreted this. This rule that I just read, this law, has been in effect 38 days. So it's a new statute, it's a new rule of procedure. But clearly there's some kind of motion to be filed by someone, and the state has to be given notice, and I'm not going to find that specifically written rule is meaningless. It means something, and we need some guidance from some appellate court or some Supreme Court. But for today, I'm determining that there's no notice been given. And so you were clearly entitled to be released from jail, but you weren't in jail, but you were entitled to be released. So I think a reasonable conclusion may be that the bond goes away, it becomes an ROR, but the conditions of the bond, such as no contact with alleged victim, only go away upon a motion and a hearing and giving the state a chance to be heard. That's how I'm reading it anyway. Mr. McDaniel, anything else for the record, sir?
Judge, I'm just going to respectfully object, and, with the things I've put on the record, and I do realize that motion is supposed to be filed, and I'll send you the stuff again. I'll send you the rule where I think it clearly says the court is responsible for that.
I just read the rule, and I'll give you another chance. If you ever see that in that rule, please let me point it out to me. It never says it's the court. It says on motion with notice to the state.
So it says the court on the 60th day and with notice to the state must. I mean, I don't know what else. I mean, it says must.
It doesn't say that. You're adding words to this rule. It never says the
B1.
court.
The last portion of B1.
If the defendant remains uncharged, the court on the 60th day and with notice to the state must. Oh, I see what you're saying. You're saying that section 2 is a continuation of that same paragraph.
Correct.
If the defendant remains uncharged, the court on the 60th day and with notice to the state must A or B. So A was done. And then there's a subsection 2, which is not part of subsection 1. Subsection 2 is a totally different subsection.
Judge, you're confusing. You're confusing part A being released from jail and part B when they're out of custody. I mean, so there is a section part A that's about when they're in custody and being released. Section B is about release from pretrial conditions.
So when there's a statute that says subsection 1, A and B, and then there's subsection 2, subsection 1 doesn't control subsection 2. It's a totally different rule. Subsection 2 is an independent subsection of Florida Rule of Criminal Procedure 3.134. So what you're trying to do is say, because in part 1, it said the court's got some responsibility, that also applies to part 2. Part 2 doesn't say that. So that's my ruling today. We'll let the appellate court give us some guidance on this.
Thank you, Your Honor.
Perhaps possibly ambiguously written rule that we're trying to follow and discern and interpret. So you've got no bond for the time being. We'll see what happens from there. Any questions, Mr. Peoples?
No, Your Honor.
Your Honor, just to
Have a good
clarify,
day.
my interpretation is section B is all dealing with that same part, and it's all, that's.
It's not
part
section
one.
B. Section B does. Subsection 2 is different. Subsection 2 says nothing about the court has an obligation to do anything. It's not my job to make a motion.
It says on the
In regards
expiration of time period prescribed in section 1, which is the court's duty there. I mean,
Yeah. So, Mr. Gill, my concern is this. My concern is you've got a case with no contact with the alleged victim. And the state sits on the case like they've done in these 2 cases and doesn't make a charging decision. I know you're shorthanded. I understand all that. But some cases have to go to the top of the line. And you've got a condition, no contact alleged victim. And that 60th day, if Mr. McDaniel's right, because y'all haven't filed charges, if he's right, automatically those no contact conditions goes away. I don't think that's the intent of the rule or the intent of the Supreme Court to take the no contact away. I think the intent is to deal with him being in custody or having bond in place. So somebody in the state attorney's office has got to be on top of these cases. And this is now 3 arrests this young man has had in 90 days, 120 days, something like that. All right, so next case is probably more confusing. Kendra Williams. Corporal, I need some help on Miss Williams.
All right, well, the next contestant comes up, Bo being here, and hi, Bo, because he's from Australia, reminded me. If you guys recall Amber, who joined us last week, and she sent us the pictures of her cats that we showed in the pre-show. This slipped by me, so this happened a couple of days ago, and I wanted to call it out. She became... through the tip jar on the bingo page, she became a monthly supporter of this channel through that tip jar. And I just wanted to say thank you, Amber. If you're lurking out there or you see this later, I really appreciate it. And I apologize that I didn't catch it sooner. That notification just slipped by me. So again, thank you, Amber.
So, Ms. Pittman, I think the criminal history the jail sent me is correct. According to it, you have no criminal history. Is that accurate, ma'am?
Correct. I've never been arrested.
Ms. Pittman, you're accused of 1 count of domestic battery. There is probable cause for it, but your criminal history is perfect. Let me see if Mr. McDaniel has anything on your behalf before I hear from Mr. Gill. Mr. McDaniel?
Your Honor, she lives here locally. I mean, we just asked to give her maybe an ROR or conditional release and just let her come back to the court date on the 25th, 9 o'clock. It's a pretty weak case.
Let me go back. I think in the other one, she said he struck her. Did he ever say that she struck him? Or was it just based on?
I believe he says it was not physical, just breaking things. I think.
Then I'm not sure there is probable cause in her case, Mr. Gill.
Judge, the state would submit that there is probable cause based on the injuries to both individuals, and that Roy, his statements were not accurate as to the injuries, showing that there was physical violence between both of them, where a primary aggressor cannot be established by the officer.
Mr. McDaniel?
Your Honor, I mean, I at the very least, it's a very weak case. I think we all recognize that this case is not going to go forward. So, I mean, I don't see, if there is probable cause, it is very, very weak, but it's up to the court.
Thank you. Ms. Pittman, I'm going to find no probable cause. Being in a fight and having injuries is not probable cause for battery. If someone says you caused those injuries and they describe the elements of battery, that's probable cause. The officer doesn't have the elements of battery in this complaint. There's no probable cause. I have no idea what happened. I just know that he couldn't determine it then, and I certainly can't determine it, the next day. So you're going to be released this morning, ma'am. There is a condition of no contact between he and you in his case. You need to understand that. There's a condition of no contact. So if at some point he posts bond, I've clearly put a condition of no contact on the record, Ms. Pittman. If he contacts you, you don't need to contact him at all. If he contacts you, you need to contact law enforcement. You can be released this morning. You have any questions?
No, sir, thank you.
Yes, ma'am. Have a good day. Terry Williams.
All right, we'll keep an eye on Judge Mercer, but let's go to Texas. Judge Stevens is getting his day started.
Okay, I'm looking at this, it says status, held in abeyance, restitution. Two cases, so we've got 13-17581 and 15-21605. Sarah Eugenia Burnett, that's you. And there are first amended motions to revoke probation that were both filed on February 14th, 2025. I don't see any action taken on these, right? This is our first appearance on this? No, what did we do before? Because I didn't make any marks on the documents, which I normally do when I hold a hearing and then make findings. Did I just postpone everything to see how she was going to do? Because one of these is like a drug matter, and the other was arrearages in an astronomical amount. Restitution is.
I believe, Judge, this is a long time ago. I believe it was in 2023. She didn't show up for a hearing on time or something like that, but that's been a long time ago.
But
As of right now, I believe we're just reviewing to see how she's doing as far as.
Yes, Your Honor. That's what I had from March 20th is reset to review payment status.
I'm looking at, okay, let's see. On 17581, the first amended motion to revoke probation. What is the restitution owed on that? In 17581.
The balance is $125,356.
$125,000 what? How much?
$125,356.
I want just to note on the, and then the other list of on the first amended motion, there's a mistake here on page 1 of the motion at the bottom where it states restitution. We got to correct that. It's showing, well, it's showing the numbers,
yes,
but the comma is in the wrong place. So we're going to just correct that without objection.
Yes.
I'm not sure where I'm not following where the court is.
There is no such numerical equation for 13,1608.
Oh, I see. Yes, sir. Okay. I'm sorry. I wasn't following.
Well, we don't, yeah. So I'm correcting it. You put the comma in the right place to reflect at that point in time when it was filed, it was $131,608. I'm correcting. Any objection on the forms? So going to, I'm going to hold that one in abeyance in 15-21605. What are we doing on, what's the arrearages as to that?
For restitution is $10,244.95.
These were both filed 6 months ago.
Right.
These motions. And so in the last 6 months, can we do the math real quick? How much she's paid in the last?
It's roughly 12,000, I believe. 1,200, I'm sorry, not 12,000. There are 1, 2, 3, 4, 5, 6. She has been paying conditions. 2, 4, 6, 8. Yeah, about $1,200.
A month?
No.
Go ahead. Can you explain why it's not better? Yeah.
Well, at our last hearing, I told you that I could pay 300 a month. So that's what I've been trying to just.
Okay, which ends up coming at 200 a month. You know, I mean, we can do the math. It's 2,400 a year for these, which would take 60 years to pay. You can see that's impossible. So what do we do about it? Does anybody have ideas? We try to make it work. I mean, we have a victim here. You were close, you know, on probation, as you know. But this isn't, the restitution was astronomical in both cases. And really in one case was overwhelming. And another case was also 5 figures. So we don't have any more drugs showing up, huh? Do we test her? You do test her? Okay. But I mean, it's 60 years. How do we? So has your income changed?
But if it was.
I don't know. Well, how do you, what do you think of victim when a victim hears that? What do you think they think? Thanks. Gee. Whenever she gets around to it, okay, but that doesn't, they don't accept that. Each of these victims were business owners. One of them a car dealer, automobile.
Kind of both. One was a freight liner, big trucks, and ridiculous stuff. What are the parties need to add anything? I'm gonna ask probation, how are things otherwise? But what I can't squeeze money out of something that is not squeezable.
Well, I mean, we're doing the best we can. This is all I can ask. Where's your income from?
I am a housekeeper and a pet.
Yes, ma'am.
My business is growing
Ma'am?
steady. My business is growing steady, but not to the place where I can.
Pay more.
Yes, sir. But I'm often trying to get in
Yes.
touch with them. I believe them.
Oh, you believe that? Oh, okay. Well, the court really didn't have much option because I just expect pay what you can. If you can't exceed 200, we're going to just continue to keep that amount and then review in 6 months. Anything else to add by anybody?
None from the state, Your Honor.
No, Your Honor.
Okay, then that's what we'll do. Reset for 6 months for review. Thank you.
Thank you.
So Ashley gifts 10 more memberships, continuing to make it rain. Thank you so much. And Carissa gifts 5. And what's interesting about this, and thank you, Carissa, is that you gave to others before you gave to yourself, because you're not even a channel member yourself yet you gifted it to 5 others. So thank you so much for that. It's really appreciated. We're going to let's stay here for a few more minutes.
Winning a lottery.
Wait, the first
But
one.
they get desperate.
First one might be the next one.
DeMarcus Meyer, please. DeMarcus Meyer. Hold on Mr. Myers, 2 cases. What we have are motions to revoke probation in each case. And those were filed on May 23rd, 2024. We had an issue of competency, and the defendant was reevaluated for competency and deemed competent to stand trial in a report that the court entered as exhibit number 1 in a hearing on March 18th, 2025. So what's been done since then? That was in March, and here we are in August. Are we ready for a motion to revoke probation hearing? Are we ready for a hearing?
Judge, I think he said he broke his leg.
See, he pleaded, okay. He pleaded true. Looks like he pleaded true back on March 18th to 3 allegations in 30326, and then to 2 allegations, which are the lesser serious with conditions, but they're all important. And I believe what the court, there's nothing on the jacket that shows what I did.
I said that you would agree to hold the MTRP in abeyance to monitor his mental health.
Yes.
And make sure that he's dependent on his performance.
Okay.
So this is a status hearing just to kind of see how he's doing after.
And
He's doing well. He's going to all his appointments. He's bringing his medication in. He hasn't missed any appointments with Spillatop. So everything has been going as scheduled and everything.
what should we do today?
I would say hold it off for another 6 months to see everything else continues to progress.
So we'll do it, we'll review it in 6 months. Where do we think the end is going to be on this? What do you think?
Say, out this next review to see exactly where he is, and then there will go from there. If it needs to, if you decide to dismiss everything, or if it's okay with you.
There any restitution on any of this?
Yes, sir.
No. Okay. We can more this assault case, if there was anything, but it's not reflected on the probation order. So what we're going to do is is come back in 6 months, keep progressing, and follow the leadership of your probation officer, and we'll see where that heads in 6 months. Okay, sir, get a resetting. Thank you.
So I just glanced up at the big board, and they've had a judge change in Miami-Dade. I don't know if Judge Glazer's head finally blew up or what, but Judge Lodi Jean is now on the bench, so I'll keep an eye on that. Before we move on to our next court, let's go ahead and talk about the sponsor of today's program, Aura. You guys know that's a big company that stepped up and reached out to me and said, we want to partner with your channel. And that's a very cool thing, because it makes all sorts of sense for them to be a partner for this channel, because they're a one-stop shop when it comes to protecting yourself and your data online. And I wanted to share a couple of things with you. This is from people who watch the channel who have taken up Aura's offer of a 2-week free trial for our viewers. And this is what they're reporting. One person said yesterday, I'm checking my Aura data removal progress. Aura removed me from all these data brokers. My name, social security number, date of birth. I never thought so much of my stuff could be out there. And that was 24 hours after that person signed up. Another one just this morning, 36 completed requests to remove my personal stuff thus far. I've had 3 critical items yesterday for potentially leaked passwords, but thankfully it wasn't anything I've ever used, but some of it was from 2018. And that person has been signed up for only about 24 hours. So the point is, what Aura is able to do for you in locating where your data is leaked online and fixing it for you is absolutely outstanding. But they offer a lot of things: transaction monitoring, spam and junk mail removal, spam call protection, which is one of the biggest things I've benefited from. They have credit monitoring. There's the VPN and antivirus. There's parental controls. They have a password manager for you, really everything you can need. And it just works, guys. I made them prove it to me before I allowed them to partner with this channel, and they've proven it. What they offer really does get the job done, so that's why I agreed to do it. Aura.com/TCF. Go there. There's a link in the description. You can scan the QR code, whatever you need. But Aura.com/TCF gets you a 14-day free trial. And, you know, you'll find out in 24 hours what they can do for you. And within 2 weeks, you'll definitely understand why it is I chose to partner with them. Again, it's Aura.com/TCF. You have absolutely nothing to lose. Support the company that supports the channel. And beyond that, help yourself. Because as you heard from the testimonies of 2 people who watched this channel and have taken the leap to give it a try, it really does make a difference. Let's do this now. Let's go to Michigan, Judge Middleton.
Good morning, ma'am. Are you Charity Ann Miller?
Good morning.
This is Judge Middleton. You're wanted in the state of Indiana, and my understanding is that you're willing to waive extradition and go back to Indiana. It's Elkhart County. At this time, you're alleged to be what's called a fugitive from justice. You're wanted in Elkhart County on a charge of possession of methamphetamine and perhaps a probation issue. Our file number here is 2515181EX. And is it my understanding, Ms. Miller, that you're willing to waive extradition and go back to Indiana and have this matter addressed?
The probation violation, correct?
I think so, yes.
Yeah, that's the only thing it should be.
All right, well, let me read you what this says. I, Charity
Okay.
Miller, am wanted in Elkhart County, Indiana on a crime of possession of methamphetamine, potentially probation violation. I waive the issuance of a Michigan governor's warrant and other procedures incidental to the extradition proceedings, including the right to an attorney unless I've already retained one. Here's the important language. I voluntarily agree to return to the demanding state of Indiana in the custody of the agent of that state. Do you agree to do that?
Yeah, I guess so.
All right, I'm gonna send this waiver of extradition form. I've signed it. Send it back out to the jail for you to sign it. Then they call Elkhart. Elkhart can come pick you up. Maybe they'll set a bond. You can address this matter. Okay?
Okay.
All right, this form's coming out for you to sign and Elkhart can come pick you up and you can address your Indiana charges. All right, thank you. And good luck to you, Miss Miller. Now we'd like to speak to Kiera Leak.
Thank you.
All right, we need to get that waiver of extradition back to the jail.
Lindsay, the snack is some fresh cherries. I picked some of them up at the store the other day, and I wish I got more because they're the best I've had in several years. But oh well, you never know. You never know when you get them, you know. Sometimes they're going to be great, sometimes they're not. Today they were just absolutely great. He's going to be a few minutes before the next contestant comes out, so let's go back to Judge Mercer in Florida.
And any conditions of bond, Mr. McDaniel, Mr. Gill, I'm also considering revocation of his telephonic rights other than with his counsel. So I'd love to hear your position on that. Mr. McDaniel?
Yeah, I don't think there's no need to take away any, was the alleged telephone calls from the jail or was?
Yes,
I guess
sir.
they were, okay, I apologize.
Yes,
And, yeah, so I don't have anything, Your Honor.
All right, Mr. Gill.
Judge, this is a secondary felony. It's punishable up to 15 years in the Department of Corrections. The state is asking for his telephonic rights to be revoked as well as his bond to be revoked in 24 CF 512. And then just a reasonable bond in the new law case, Your Honor.
Thank you both. Mr. Williams, I'm going to set your bond in the new case, a tampering charge of $25,000 bond. I'm going to revoke your bond. In the previous case, you did have a condition of bond to have no contact with the alleged victim. There's evidence that you violated that repeatedly. I'm going to instruct the jail to remove all your phone privileges with the exception of telephonic contact with your attorney. No phone privileges because it appears you've abused that. So they'll stop all phone contact, period, other than your attorney. And we'll see where it goes from here. But you have no bond in the old case. So there's no point trying to post bond in the new case, Mr. Williams, because you wouldn't be released. Mr. Williams, do you have any questions?
Yes, sir. This is my wife. And the judge didn't never tell me I couldn't talk to her.
Trying to remember
When
if I
I went-
watched the video this morning, and in this case, I don't think I wasn't the judge, but did I watch the video or did I just read the file? In this case, I believe it's on your paperwork from the jail. I think in this case, the jail actually wrote it down, but let me go look at that and see. I don't know that I had time to watch the video on yours, but I certainly can.
Yeah, he didn't never tell me I couldn't talk to her.
Mr. Williams, don't say anything else. I want to try to answer your question, but I don't want you to say anything that's going to hurt you. But I feel confident the judge did do that because that's a rule in Florida that you must impose a condition of no contact with an alleged victim unless the victim is there and the judge can make certain findings that the victim's wanting to have contact and so forth. Let's see, what was the case number? I think it's 24-512 CF.
Yes.
The good thing, technology has come a long way, Mr. Williams, so I actually have the ability to watch that first appearance now.
Judge, I'm looking at a copy of the first appearance paperwork on September 21st of 2024. Judge Young's paperwork signed no contact with victim as a condition on the paperwork.
Mr. Williams, the paperwork says no contact. Would you like for me to watch the video from your
Yes, sir,
first appearance? Okay. I'll
Yes,
watch the
'cause he
video.
didn't tell.
We'll watch the video. It won't take just a minute and I feel confident they did. I cannot imagine the jail writing it down on the sheet. Them not writing something that should have been written is one thing. That happens all the time, unfortunately, but writing something down that shouldn't have been written is a different type of error and much, much rarer. So here we go right here. Got to turn my volume on.
Felony possession of method. Four charges against you. Where's that? Shit. See. Where's that?
I don't know about you, but I can't listen to that. So while they sort that out, let's go back to Judge Middleton. He has his next contestant.
Good morning, ma'am. Are you Kiara Shauna Tiana Leak?
Yes, sir.
All right, my name is Judge Middleton. I'm here in Centerville. You're from Pontiac?
Yes, sir.
Also with me is Mr. Keith Stickley. He's the Chief Public Defender for St. Joe County. The prosecutor is charged you with resisting and obstructing a police officer. Let me read it to you. The complaint alleges that on August 6th, that'd be 2 days ago, in the city of Three Rivers, you did resist, assault, batter, wound, oppose, or endanger Jason Van Dyken of the Sheriff's Department. Resisting and obstructing, the way it's charged, is a felony. It's punishable by up to 2 years imprisonment or fine of up to $2,000. Because it is a felony, you have a right to have a preliminary examination and a pre-exam conference in this case. So let me take care of that first.
Can I say something, sir?
Sure, I'll give me a minute.
Okay.
I'm gonna appoint an attorney. I'm gonna set a pre-exam conference for August 19th at 8:30 and a prelim if needed for August 26, 25 at 1. Now, I don't know much about you at all. There's no criminal history. There's nothing in here. Let me ask you a couple questions. Do you still live on Possum Street in Pontiac?
I live on 596 Ras Cobb in Pontiac.
How'd you happen to be in Three Rivers?
I'm a travel nurse.
Traveling nurse?
Yes, sir.
Were you doing a stint at Three Rivers Hospital?
Optalis.
Oh, Optalis. Are you on probation or parole?
No, not at all.
Are you RN or LPN?
I'm a RN.
They don't hand those out like bubblegum cards. You obviously have something on the ball. You have a family?
Yes, sir.
Tell me about that.
I just paid my mom through school and she just became an LPN. I have 2 kids that my mom is taking care of right now. And it's really just us.
All right. So you're employed, you're not on probation, you're not on parole. Have you ever been charged with anything like this before?
No, sir.
I'll tell you the truth, there ain't much info in here. I don't want you to tell me anything about what happened. I'm just gonna tell you what I know. The allegation is that you got stopped in the city of Three Rivers for a non-moving violation. I don't even know what that means. Deputy asked Ms. Leak to exit the vehicle. She would not and refused. Gave her several chances and informed her if she didn't comply, she would be removed. So they pulled you out of the car and charged you with resisting obstructing. Where did this take place? McDonald's?
Yep, I had just got off work at 11. I had worked from 6 in the morning to 11 at night. And I pulled up into the McDonald's just to get something to drink before I went to the hotel.
All right, I'm gonna let you out of jail. I'm gonna give you a bond of $2,000 PR. The only condition is that you show up for court. Now, they're going to give you some paperwork. The bond is $2,000 personal recognizance. I'm not even worried about any bond conditions. You're a registered nurse. They're going to give you paperwork with your lawyer's name and number on it. I believe her name is going to be Rhonda Ives. I want you to call that lawyer, make an appointment to discuss your case with her. There may be some body camera videos or car videos or police reports that you guys will want to take a look at. Your next hearing is set for August 19th at 8:30. Are you expected to be back at Optalis?
I have a great relationship with them and I work there often, probably like 5 times a week.
All right, well, I'm letting you out of jail. So I want you to call the lawyer, make an appointment. Your next hearing is August 19th at 8:30. Okay? You have any questions?
I just wanted to know, are these charges is what you're also charging me with too?
No, I'm not charging you with anything. The prosecutor charged you. I'm just telling you what the charges are.
So the prosecutor did actually with what the officer said.
Now, this is important to you because a felony charge could affect your nursing license. So you need a lawyer. So I got you one and I gave you a PR bond. I can't do much more than that for you at this point, but I'll see you on August 19th.
Okay.
All right, thank you.
Ashley, since you're the keeper of time, would you be willing to do me a favor and put her down for August 19th so we remember, please? Because I'm curious to see where this goes. So if I heard it correctly, they stopped her for a non-moving violation. No idea what that means. And then arrested her for resisting and obstructing. this is one of these things that I struggle with just a little bit. When people get arrested for something like resisting arrest, but they don't have any other charge, it feels like that needs to be a companion charge to me along with something else. Because the idea that you can be arrested for not wanting to be arrested, and that's the only thing, has never made any sense to me. But if you differ, let me know in the chat. Let's go back to Judge Mercer. I think I nudged this past the feedback loop, but let's see.
All right, so that's not going to work. Let me try to get to the part where they. All right, so that's not going to work. The problem is I'm getting feedback because I got my speaker on my computer on. It worked for a while. All right, so there is a condition of no contact and revoking your bond. There's evidence you violated that condition of no contact multiple times. Any other questions, Mr. Williams?
I just want to know, can I get a bond for it? That's all I want to
No,
know.
you cannot get a bond. It appears you violated what a previous judge told you not to do. So no, you're not getting any other bond. I'm revoking that bond. Do you have any other questions, sir?
Sir,
Have a
that's
good
my
day.
wife, so I don't know.
No contact, even if it is your wife, you're accused of a crime on her, Mr. Williams, and the judge ordered you to stay away from her. And now you're accused of contacting her from the jail and encouraging her to drop the charges. That's why you've got no bond. I wish you the best, sir. Next
I'll get the
case.
court in order, Judge.
I'm sorry?
I'll get the court in order. on
Thank
that.
you. Thank you, Mr. Gill. Serena Shipes is next. Ms. Shipes, good morning. Ms. Shipes, you're here, ma'am, because you've been accused of one count of driving while licensed, suspended, or revoked with knowledge. Ms. Shipes, I've read the complaint. In your case, there is probable cause. I took a look at your criminal history, and it appears, ma'am, that you've been to prison 3 times. Is that accurate, Ms. Shipes?
Yes.
It also appears you have, I think I counted 6 prior driving license suspended, but the most recent one was 6 or 8 years ago. So it has been a while since you've had one. I am aware of that. Let me see if the attorneys have any additional information, Ms. Shipes, before I set you a bond. Mr. McDaniel, anything?
No, just take into consideration, this is a financial issue only that's dealing with criminal cases that she has in Washington County. She did have a deal worked out with them, but she was unable to fulfill the payments that the clerk's office wanted her to make on all the felony cases that were out there that she's had over the years that you described. So she's trying to do the best she can, I guess, to get her license.
Thank you, Mr. McDaniel. I did not catch that. It was a financial related suspension. So thank you for pointing that out. Mr. Gill, anything from the state?
Nothing from the state, Your Honor.
Ms. Shipes, I'm going to set your bond at $5,000 cash or surety because of the history primarily, ma'am. You have a condition not to drive a motor vehicle unless you get a valid license. Ms. Shipes, if you get a license, you can drive, but you cannot drive until you get a valid license. It's a cash or surety bond, so you can go through a bondsman. Ms. Shipes, do you have any questions, ma'am?
No.
Have a good day, ma'am. Next, we have Aaron Summerlin. Now we've got Mr. Green and Ms. Jernigan here. We'll take that case next. Mr. Summerlin, good morning. Mr. Summerlin, Mr. McDaniel's added you on the docket. He's trying to get your case resolved. So listen to your attorney and we'll see where we go from there, sir.
Your Honor, I spoke to Mr. Summerlin in case number 25370MM. He's going to plead no contest to the charges listed. You understand he'll be sentenced to 6 months in the county jail. He'll have 29 days jail credit, $722 fine. He'll be adjudicated guilty. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
Thank you. Mr. Gill, is that agreeable with the state?
It is, Your Honor.
And Mr. Summerlin, did you hear that agreement, sir?
Yes, sir.
And Mr. Summerlin, any questions about that agreement?
No, sir.
Is that the plea that you would like to enter?
Yes, sir.
Mr. Summerlin, I'm going to accept your plea of no contest. in case number 25-370 MM to the charge of battery. Sir, I'm going to judge you guilty of that offense. Sentence you to 6 months in jail, but Mr. Summerlin, you have credit for 29 days you've already served. I'm also going to impose a standard court costs and fines set by state and county law at $722. Mr. Summerlin, there's no probation involved in this sentence, sir. What that means is when you finish this jail sentence, you're released, no further probation or anything. Mr. Summerlin, I do wish you the best. Do you have any questions?
No, sir.
All right, sir. Have a good day.
Sure will.
Let me do Mr. Ivy last because it may take a little more time, Mr. McDaniel. So let me finish your cases and we'll do Mr. Green's case. Sean Bass is next. Mr. Green only has 2 other pleas. Shouldn't take just a couple of minutes. This is State versus Sean Bass. Mr. Bass, good morning. Mr. Bass, Mr. McDaniel's added you on the docket today trying to get your case resolved. So listen to Mr. McDaniel, please.
Your Honor, I spoke to Mr. Bass in 25195 MM. He's going to plead of no contest to the charges listed. The understanding he'll be sentenced to 30 days in the county jail. He'll have 22 days jail credit. There'll be a $370 fine. He'll be adjudicated guilty. He has signed his plea waiver form, waiving his right to a jury trial and all this.
Madam Clerk's question, is he pleading on both counts?
Correct. Just both of them run concurrent.
And Mr. Gill's that agreeable with the state?
It is, Your Honor.
Mr. Bass, did you hear that agreement?
Yes.
Mr. Bass, is that the plea you would like to enter to resolve these cases, sir?
Yes.
Mr. Bass, I'm going to accept your plea of no contest in case 25-195 MM to the charges of affray and trespass, structure, conveyance, to judge you guilty of those offenses, sentencing you to 30 days in jail on each case concurrent. But Mr. Bass, you have 22 days credit on each charge, so you have a total of 8 days left. You may do a little less than that. You may not. That's between you and the jail. But I'm also ordering the court costs and fines of $370 only on count 1. That will become a civil judgment against you. Mr. Bass, Mr. McDaniel, I feel like has probably told you this. Be aware under the recent procedural changes with our clerk's office, your license will be suspended if you don't pay that fine after a certain period. I think it's 90 days perhaps. So be aware of that, even though you may not have enough time left to get the fine worked off is what I'm saying at the jail. So if you don't get it worked off, you've got to pay that fine or they're going to suspend your license, or you've got to enter into a payment plan with them. They're pretty reasonable, very reasonable about the payment plans if you choose that option. Mr. Bass, no probation involved in this sentence. Any questions, sir?
No, sir.
Wish you the best, Mr. Bass.
Yes.
Mr. Dixon, good morning. Mr. Dixon, you're here for a bring back. Mr. McDaniel's trying to see if we can get your case resolved. Mr. Dixon, please listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Dixon in 25379 MM. He's going to plead of no contest to the charges listed. You understand he will be sentenced to 9 months in the county jail, 24 days jail credit, $370 fine. He'll be adjudicated guilty. And if he does, find some kind of rehab that he can go to, then I don't think the state has any objection to him going to it. But at last time we couldn't. I don't expect anything's going to change. So, so we're going to go ahead and resolve. He has signed his plea waiver form, waiving his right to a jury trial and call witnesses.
Thank you, Mr. McDaniel. Mr. Gill's had agreeable with the state.
Yes, Judge, no objection to a rehab facility if he qualifies.
So, Mr. Dixon, I'm not going to promise you that I'll let you go to rehab. I would love for you to go if it's the right fit and if it's long enough. I certainly will consider it. The state's not opposing it, but Mr. McDaniel's telling me they hadn't found one in the past. So, Mr. Dixon, you very well may end up doing the sentence. If they find a rehab, you'll come back to court and we'll talk about where it's at, how long it is, and so forth. Mr. Dixon, knowing all of that, do you have any questions?
Can I ask one question? Why
Sure.
did the police come from me there and drop me off? I hadn't did nothing.
I don't understand your question.
I'm trying to figure out why I'm in jail.
Judge, I'm not sure if he actually wants to plead right now. I've had multiple conversations with him. Just to remind you that the stuff with the drug rehab is because he can't read and write. That's the issues with that. And
I remember now.
There's some learning disabilities here, I think, and I'll call with him some more. All right.
Okay.
Good luck to you.
So, Mr. Dixon, we'll see you at a later court date, sir. So that brings us, I think that's it for your cases, Mr. McDaniel. Anything else you have, Mr. McDaniel?
Nothing else, John.
All right, so we have one of Mr. Green's cases. Mr. Green is here in the courtroom. He's been waiting patiently. This is State versus Shawnest Ivy. Mr. Ivy is here on a violation of state probation. We do have our probation office here now. Ms. Jernigan, I apologize you weren't given advance notice. Ma'am, we're going to try to fix that on these pleas in the future. But Mr. Ivy, listen to Mr. Green, your attorney. I think there's a framework for a plea agreement here, possible plea agreement. And I don't have the case number, Mr. Green, in front of me. So if you
It's
could put that on there.
24-610, Your Honor.
Thank you. And Mr. Green, where do we stand?
Your Honor, I've talked to Mr. Ivy again last night, or late yesterday afternoon. And he's entered, the state has offered for him to go to modify to give him 6 months of drug offender probation for the curfew. I've talked to him and he signed the paper to enter that plea. But what he'd really like to do is to go to a drug rehab center. We don't have one. He hasn't been screened for one yet. But what I'd ask the court to consider is letting him plead to this and get on the drug offender probation and let them go ahead and the probation officer, just talk to probation officer, Ms. Jernigan, and see if they can go ahead and get him from drug offender probation to into an inpatient drug treatment and bring him back once that is if they can find him a place.
So is the inpatient drug treatment part of the plea, or is it something, because last time he was going to do it voluntarily and then he got arrested before he could?
He'll do it voluntarily, but it's not part of the plea, but he would voluntarily do it. And I think it could, the probation office could help him get a placement. And then we could modify his probation for the drug offender probation to a inpatient drug treatment.
Okay, so I understand your position. Mr. Gale, tell me what the state's position is.
Judge, yes, I believe that the ultimate goal was to get Shawnest Ivy into an inpatient drug treatment facility. I've been in contact with Ms. Colbreth. She's been working on that. I don't believe she has said that he has been admitted into a facility. I think she's working on a bunch of that. In the meantime, I had proposed, well, if that doesn't, come to fruition, I would be willing to do 6 months DOP. And that was the offer I tendered. I think that based on some conversations, the only concern with DOP is that there's a transportation issue that Mr. Ivy, and I don't want to send him up to fail, that he can't get to some of these things that DOP requires him to do. That's where we are, Judge. I'm happy to, I really don't know what to do at this point, other than that's the state's offer, inpatient drug treatment or 6 months DOP. And it's up to him and what his advice of his attorney.
Thank you both. Mr. Ivy, where do you live at?
I live on Highway 2 out there, Troy County. My thing is, John, is this here. I can do once a month, check into the probation officer, but I don't have a job and I don't have a license, so I don't want to get caught driving with no license, trying to make it till every week up there, because I got to check in every week. So my thing is I can show up once a month, but the weekly thing I can't do.
So on drug offender probation, there's a condition for a certain number of weeks that you must come in once a week to be drug tested. Is that right, Ms. Jernigan?
Right.
I want to make sure he can hear you. So that mic, I don't know if that microphone's live or not.
No, sir, it's changed.
Okay.
On drug offender probation, they'll report into the office on a monthly basis, but they have a curfew. The weekly meetings would come into play when he has to go to drug treatment, and that's weekly group meetings, and then another meeting that's an individual meeting. So 5 times a month, he would have to go to treatment meetings.
Are any of those located near the Campbellton area?
No, they occur in Mariana.
Okay. Mr. Gill, that's the state's offer, is that right?
Yes, Judge. I will make another offer today. I don't know if the court would accept it. I believe that we're rescheduled, if we don't have anything resolved today, that we're rescheduled for an evidentiary hearing on the 20th. The state would offer today 120 days jail. This is a low-risk technical violation, Judge. Given that he has over 90 days, he's now at, I believe, 100 days. The state would offer 120 days with, he has credit for 100, so that's 20 more days left. And then that the only other condition that is modified is that he has a curfew. I'm willing to.
I wouldn't accept that.
Okay.
When he pled originally, Same prosecutor, same defense attorney. Well, maybe Mr. Green wasn't original.
I don't think
He
so.
said he needed help.
Right.
And I went ahead and let him enter the plea, and he was going to get help, and he didn't make it a week before he was arrested. It was 7 days, I believe. So no, I'm not going to accept a resolution that doesn't give him the help that I believe he needs, and he himself said he needed. So I wouldn't do that.
Okay.
I have no problem with the drug offender probation. You need to understand there is a point I'm being told you will have to report weekly, and if you can't do that, you don't need to take it. I was going to have a problem going forward to the VOP hearing. Lastly, if you take the drug offender probation and you violate, then I'm not going to be sending you to drug treatment. Let me back up. If you violate in a willful and material way, in other words, if you test positive, if you don't report in, if you disappear, if you commit a new crime, if there's allegations against you like that, then I'm not going to send you to drug treatment then. I'm going to send you somewhere else. So, Mr. Ivy, you need to understand, I want you to make it. I'll be your biggest fan, but if you can't do this, don't commit to it. So, do you want to take the drug offender probation, or do you want to just go to the VOP hearing?
Shoot, the ball in your hand. If it's left up to you, like to me, if I go to VOP hearing, I know I can win the VOP hearing, but when it's all said and done, it's up to you. You see what I'm saying?
I don't know if they can prove you violated your probation or not. I know the allegations was a new charge. It was a misdemeanor. And in that new case, the state has shown the misdemeanor prosecutor has shown some desire to dismiss that case if you enter a plea. In this case, the second violation was allegations regarding a positive urinalysis at the jail. That's all I know. And whether they can prove it or not, I don't know. But that's the allegations against you as I understand them. So you've got to decide whether you want to go to the VOP hearing or whether you want to take the drug offender probation and get a shot at drug offender probation. And if you complete it, great, everybody's happy. But you need to make it a whole lot more than 7 days before a violation like last time. An alleged violation, at least.
What about this? Stephanie said she was gonna get me a halfway house. I talked to her over the phone. She said she was gonna get me a halfway house.
She's had a month to do that. It's been 3 weeks, Mr. Ivy. I have no idea why it's taking so long to get you somewhere. I don't know. I'd love you to go. I'd sign for that today, but they haven't found you a place apparently.
There's a difference between the halfway house and the rehab. She said the halfway house, she can get me there in the next day or two. I talked to her over the phone.
What do you mean by halfway house?
A halfway house is like I don't have no lights on at my house. So in other words, what she's saying is she can get me there as live so I can live there and go to all my meetings and whatever I have to go to.
Do they have a drug treatment portion or a part of that?
That's what she said. I talked to her over the phone. So I should take the drug from the program, whatever. I'm just trying to make it. So.
Mr. Green, are you satisfied that
If he wants to try, you're gonna have to come in once a week to do things, and if you don't do them, they're gonna violate you.
Let me ask you a question about that. You said when the counseling portion starts, when does that begin? Immediately, or is there a certain time period when that?
No, we have 30 days to make the referral. The evaluations occur every Tuesday morning at CARE. So if he was released today, he could possibly get into an evaluation on Tuesday. And then based on that evaluation, the weekly groups would start the following week.
And the weekly groups are in Mariana?
Yes, at CARE.
So at some point within the next 30 days, you would go to the evaluation. And then after the evaluation, there's a good chance you would then go to weekly meetings. If Ms. Colbert finds you something in the meantime, that it's an inpatient program that you want to go to, then we'll get you back and send you to that. I don't have a problem with that. But I don't have my faith they're going to do that because they've had a month to do it and they hadn't found your program yet. So there's some issue. I know that you were accused of leaving a program in the past, and I don't know if that's the issue or if it's something else. I have no idea. Today's the first time I've heard they couldn't find a program. So Mr. Ivy, do you want to take this off, or do you want to wait and see, hope for something different comes through?
Sir, I got to give it a shot. I got to get out there. I'm doing dead time here, I'm doing dead time. I got to give it a shot. It's time to change. I didn't do nothing wrong from the get-go, but I got to give it a shot. I got to get out there, sir.
Okay, so you do want to take the drug offender probation. Is that what you're saying?
Yes, sir. I just don't want to have no issues with Miss Journey because we had issues in the past. I don't want her to just violate me, because, but I take it. I
won't be the officer.
Ms. Jernigan says she won't be the officer.
Okay, thank you. Yes, sir.
That seals the deal right there. Okay,
Okay.
so Mr. Green, I'm gonna ask Mr. Green to put the agreement on the record. Let's make sure that we're all on the same page, and this is what you want to do, Mr. Green.
Your Honor, on behalf of Sean S. Ivy, in case number 24610, and move to withdraw his form of plea of not guilty and a plea of no contest to violating probation agreement with the state subject to the court's approval. So the court would modify his probation and adjudicate him guilty if he hasn't already been. Sentencing to 100 days in the county jail, giving credit for 100 days in the county jail. All prior conditions would be reimposed. The $500 monetary obligation added to his probation. He'd be placed on 6 months drug offender probation with a curfew. It's a low risk technical. And I think that's it, Your Honor.
One other condition I
Thank you,
think
Mr. Green.
we discussed, and that was dismissing 25215 the trespassing case.
Yes, right. At this time, the state would move to dismiss that case, and I'll file a written dismissal of that as well. I have a score sheet here.
And that plea agreement's acceptable, Mr. Gill. Thank
One
you.
more
And
question.
Mr. Ivy, yes, sir.
One more question. If I decide to take this year and a day, right, I come back in front of you, I got 308 days credit. Will you accept that?
I don't
With
know
the year
how much
to
your
date?
total credit is, Mr. Ivy, but it's all calculated. It's all there. I mean, we can go back and calculate. You have 100 days since your last arrest.
Do you show it? Do you happen to have his credit there, Corporal?
You got it.
We have a split credit. One is 108 and one is 205.
Most years.
So I can go and resolve it. I can get this over.
316.
313. So his other offer was 366 in prison with 313 credit?
My offer was
Why in the
a
world
year
would you
and a day.
take house arrest or drop off if you?
That's what I'm trying to say. That's why I can go and resolve this right now. I can get this over with right now. I
Mr.
ain't
Gill, that
gonna-
was
I
the
ain't-
offer, wasn't it?
I've offered
Yeah.
Mr. Ivy also a straight, it was I believe, I don't remember what it was, but I offered him a DOC offer
It
to
was a
resolve
year
this.
and a day, wasn't it, Mr. Green?
I believe it was a
got
year.
it.
I don't know exactly, Judge.
Okay, so Mr. Ivy, let's make sure the other offer that was made to you at your last court date was 366 days in prison, which is a year and a day, with credit for the time you've served. You now have more credit than you did back then, so you have a total of 313 days credit. So
Well,
are you saying you'd rather do that?
I'm saying that's I just go down there. Yes, sir.
Okay.
I want to do
Mr. Green?
That'd be his best deal. He'd be off probation in a couple of weeks. He go down there and get his teeth cleaned and come home, and he's through.
I think Mr. McDaniels explained to him the transport process because he said something about leaving today. Mr. McDaniels explained to him, I believe. That doesn't happen daily. The transports are weekly or bi-weekly.
But he wouldn't be there very long. And he'd be through with it. That'd be his best deal. Then he'd start all over again.
So, Mr. Ivy, let me wait till Mr.
I'll
Ivy.
take it.
You would rather do the year and a day in Department of Corrections, convert all financial obligations to a civil judgment, give you credit for the amount of time you served, which the jail is telling me is 313 days, and no probation, no house arrest, no DOP, nothing left. Is that what you want to do?
Yes, sir. And could you please put it on writing in that paperwork, sir, so when you get down there, they can see all this credit. Please, sir.
I will mark all his credit on there.
I'm going to ask you to go ahead and do that now.
Thank you, sir.
Well, he would have to sign it.
Oh,
So let's go ahead and take this one that he's signed and make changes. I'm going to read him to those changes and make sure that's what you want to do. That way you don't have to get it to the jail for him to sign another one.
I can get him.
So
out here
while they're
signed.
getting that signed, I'm going to read it to you when they get it done. Mr. Ivy, let me get you to raise your right hand, please. Mr. Ivy, do you solemnly swear or from the testimony about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Ivy, you accused of violating your probation in case number 24-610CF. In that case, you can put your hand down, Mr. Ivy. You have the right to a violation of probation hearing. Mr. Ivy, if you go to that hearing, the attorney will represent you at that hearing. The state will try to prove that you violated the terms of your probation. And that attorney, Mr. Green, would argue on your behalf. And if they don't prove it, you'll be reinstated on the supervision you were on previously. However, you have the right to waive that hearing. And if you waive that hearing, there will not be a hearing. You don't get to call witnesses. You don't get to cross-examine the state's witnesses. And in exchange for that, a specific sentence is entered. Do you understand all of that?
Yes, sir.
And do you want to waive the right to that hearing with the understanding that you'd be sentenced to 1 year plus 1 day in the Florida Department of Corrections and given appropriate credit I've already put on the record today. Is that what you want to do, Mr. Ivey?
Yes, sir, which is 308 days credit, right, sir?
313.
313.
Would you
yes,
rather
sir.
have 308 or 313?
313. Yes, sir.
Mr. Ivey, do you feel like this is in your best interest?
Yes, sir.
All right, so you've already signed a waiver of rights form, but that waiver of rights form, which you've already signed, had a different agreement on it. It referenced the drug offender probation. So Mr. Gill has modified that form, and I'm going to read to you the changes, just so we're all on the same page, because you want the specific credit on the form, and I would too if I was in your shoes. So we're going to make sure it's there, okay?
Sure.
Help me remember. Was it 308 or 313?
313.
Okay, so let me see that form.
Okay,
Mr. Green, are you satisfied these changes reflect the current agreement?
exactly, Your Honor. And Your Honor, I went yesterday and he signed that in my presence, and you understand what we're doing. You just marked out what you had signed yesterday and put on what you agreed to today. You understand that?
Mr. Ivey, you understand that?
Mr. Ivey, you understand that we just marked out on the form you signed yesterday what the agreement was, and we put the correct, what you've agreed to right now, to a year and a day with 313 credit.
Okay. So the changes on the form are the DOC now says 1 year, 1 day. The day's credit says 313. A civil judgment on any financial obligations, and your probation is revoked. Mr. Ivey, I'm going to accept that plea, that admission that you violated your probation, revoke your probation, sentence you to 1 year and 1 day, which is 366 days in the Florida Department of Corrections. I'm going to give you credit for 313 days you've already served. Any financial obligations will become a civil judgment. Mr. Ivey, I'm going to find this is a guideline sentence, Mr. Gill? Or was it not?
I believe if it is, it's barely under a guideline sentence, Your Honor. This course you should reflect, I think, is it 14?
I got one more thing, Your Honor.
So hang on just a second. I'll be glad to answer that. So it's either it's 41 total, 47 total points.
It should be guidelines.
So it's a guideline sentence.
It's also low risk.
So Mr. Ivey, there's no probation involved in this sentence. Mr. Ivey.
Yes, sir.
It's my belief you still need some inpatient drug treatment based upon your prior statements. So I would encourage you, when you get out, if you want us to help trying to find your program, contact Ms. Colbert or contact Mr. Goodson with the probation office, and they can try to find you a program. You need to do that before you get in trouble. Mr. Ivey, I don't want you to get out and get a new charge and then say, I need treatment. If you need help, as soon as you get out and get this behind you, let's get you some help. You'll be going voluntarily. That would be a good benefit if that's something that you think would benefit you like you felt at one time. Now, do you have any questions, Mr. Ivey?
Yes, sir. I got one more resolution. You said on that paper that I signed, when the day that you were gonna give me additional 45 days if I signed it. I got it on black and white, Your Honor.
What?
Yeah, that was, I think at that time, the credit, there was some conversation about artificially increasing his time on a different sentence. It may have been 18 months in the Department of Corrections. Yeah, we're going to try to increase it to try to get it down where it was less than the amount of time he would do in the county jail.
I can try to pull up the email, Judge. I think I had it in the email.
Mr. Ivey, there's been so many conversations back and forth. The attorneys did approach me about that. But Mr. Ivey, this is your sentence. That's the sentence I've imposed, and I do wish you the best. Mr. Ivey, any questions?
No, sir.
And lastly, your other case, your 25-215 is being dismissed pursuant to this plea agreement. So that misdemeanor trespass is dismissed, Mr. Ivey.
Yes, sir. Thank you, sir.
Yes, sir. I wish you the best.
Okay, real quick, Bo, I do need to chide you just a little bit. I agree with the people in the chat. Stop saying that you're sorry. Today is the perfect example in my mind of why this community is so special. So if you're new here today, if you're lurking in the background, pay attention to what's going on, please, because there is a friendliness in this place that isn't present in other places. There's certainly a generosity. 36 memberships have been gifted so far today, and there's an hour left in the show. We have a good law discussion going on, and we're learning things, and that's what makes this place so special. Everybody's generous. Everybody's caring. We have fun. We're playing bingo right now. We're learning the law. We're watching some good cases. This is why this has become such a special place and why I'm so blessed to be able to lead it. So thanks seriously to all of you. I need to step out of the studio for there we go. I keep hitting wrong buttons. I think I got it right now. I need to step out of the studio. I'll be right back. But in the meantime, here's Judge Stevens, who is not Judge Stevens because he just cut his feed. Well, I'm glad he did it before I stepped out of the studio. Who do we go to now? Let's go to Judge Elmore. We'll do that. We'll make that happen. I'll be right back.
And 3-9 FH. Appearances, please.
Joanna Carey for the people.
I'm Jeff Harrison. I'm here on behalf of Mr. DeMambro. Mr. DeMambro appears via Zoom from MDOC.
Thank you. Mr. DeMambro, are you able to see and hear the court this morning, sir?
Yes, Your Honor, I am.
Thank you very much, sir. All right, we're here today for a final pretrial conference. I conducted that a few minutes ago in chambers with counsel. The objective today is to find out what is happening with these cases, as these 3 cases are all set for a trial date on August 26th. The first 2 cases, 3-7 and 3-8, are joined by a previous order for joinder. And I'm told that in those cases, there's no resolution. Is that correct, Mr. Harrison?
That is also correct, yes.
All right, thank you. Now, those 2 files, while they might have the older or lower case numbers, are actually events that allegedly occurred on January 30th of 2025. Making the file ending in 3-9 the older case, which the alleged events occurred on or about November 3rd of 2024. And in that file, Mr. Harrison, I understand that there is no resolution. Is that correct?
That is correct, Your Honor.
All right, thank you. All right, that means that that case is the one that will go to trial, since it is the oldest, at least as of time, and not doesn't have the lower case number, but it does have the older in time alleged event. All right, Mr. DeMambro, this case will go to trial on August 26th on Tuesday. We begin in the morning at 9 a.m. with jury selection. We will have you written to be brought up here for trial. One moment. All right, Mr. DeMambro, the next thing I'm going to say, I say every time there is a case that is set for a trial date on a final pretrial conference. What I'm about to say, again, I say every time. There is no opinion about the case. All I know is what you're charged with. So I don't know anything about the allegations, I'm sorry, the actual facts alleged behind them. Well, what I do is I tell people, today is the last day to enter a plea if they want to. Now, that doesn't again say, or I'm sorry, that is not at all intended to suggest I have any opinion. I do not. I tell this not to force defendants to enter a plea, but instead to force the attorneys out there to do all their jobs, their negotiating skills, their arm wrestling tactics. So that way I know that they have exhausted it all, and we are definitely going to trial. The reason why I do that, again, is not to pressure the defendant, it's to focus on the attorneys, because I now have to have my staff issue 90 to 120 different letters to potential jurors. Those jurors all have to take off time from work, get babysitters, somebody to watch grandma or grandpa, rearrange medical appointments, get somebody else to sub for them at work. Plus, the prosecutor's office and the defense attorneys need to issue subpoenas and have witnesses show up who have to do all those same things. So before I make those wheels start moving, I make sure the attorneys aren't wasting our time and they have done all they can. They have assured me they have exhausted all negotiations. Therefore, this case will go to trial. I also do it because I don't like people coming up on the day of trial and hoping that they're gonna get a better deal, because if they do, then I lose one of those trial dates. So again, please take no offense. I'm gonna have this conversation with some other people today as well. Not a big deal. Do you understand, Mr. DeMambro?
Yes, I do.
All right, good enough. Thank you very much. All right, and oh, by the way, it's also to let you know, so you understand the choices that you make and what's gonna happen. So you also aren't sitting there wondering, hey, am I really gonna go to trial that day? Nope, you and I and the attorneys know that we are going to trial. All right, anything else today, Ms. Carey?
Oh, thank you.
How about you, Mr. Harrison?
I have nothing to add, Your Honor. Thank you very much.
Thank you. Mr. DeMambro, do you have any questions for me at this time?
I'm not at this time, Your Honor.
All right, good enough. All right, thank you very much, sir. We'll see you on Tuesday, August 26th. We are adjourned.
Thank you.
Thank you.
All right, I've had to reorganize here a little bit because a whole bunch of feeds just went silent, but let's go back to Judge Middleton.
Want to sit here?
Yep, sit down right there, bud. All right, good afternoon, Mr. Gary. This is Judge Middleton. Also,
Mr. Middleton.
Good morning to you, sir.
Good morning, sir.
Mr. Stickley is here from the Public Defender Office. They charge you with a couple of misdemeanors. Let's talk about them. They allege in this complaint that on or about August 7th, which was yesterday, you did make a domestic assault upon your girlfriend, Ashley Marie Brown, and you did interfere with a crime report by attempting to take her phone away from her and throwing it on the ground. Domestic assault is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. The other charge is a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. Mr. Gary, if I let you out, where would you go?
It's to my house.
On 6th Street?
Yes, she when she left, she took my phone. And she.
All right, well, does Ashley live at the same address?
She's my fiance.
Well, if I let you out of jail, you can't have contact with her.
I'd go with I'd have my mom and dad come and get me. I guess, right?
All right, your mom lives in Constantine.
No, my mom lives in Colton.
Oh, she's in Cole, that's right. Well, I'm gonna show a plea of not guilty. I'm gonna appoint an attorney. I'm gonna set an attorney pretrial for 9/5/25. That's my date with Attorney Ives. That's at 8:30. The question is what I would do with your bond. I'm not gonna just leave you in jail indefinitely on this charge, but I don't want any other problems. Daniel, you and I have met a number of times over the years.
Yeah, you know, my word's good, sir. I promise you nothing will ever happen. It was just a misunderstanding between me and her over a phone, man. And she told me she left the phone. It would have been different for me, her trying to grab my phone or her phone, you know. She would just said something.
All right, here's the deal. Lay out of jail on a bond. I'm gonna set bond at $1,000 PR.
Oh, you mean you're gonna let me out on PR? Oh, fucking sorry, sir. Thank you, sir.
No, don't undo it.
I won't, I promise you.
No drugs and no alcohol, Daniel. You sometimes can go down and test as directed. No weapons, no assaultive behavior, and no contact with Ashley Brown. So you're gonna have to stay at your folks.
For how long until next court date?
The next court date is September 5th.
Every 4 to 6 as needed. And he does.
Do you have anything else holding you?
Nothing. This is all, I'm nothing. I'm trying, man, I'm trying to live a better life. You know, I haven't been here for years.
Yes.
Ever since that stuff went down over there, I'll be getting it, home
Well,
invasion
you
stuff.
do owe me some money on a disturbing the peace case. You're on a payment plan. And you keep shooting yourself in the foot. And I want you to make payments on a payment plan. All right, Daniel, no drugs, no alcohol, test if demanded, no contact
Yeah, I will do
with
some of
the
that
ground,
stuff.
no weapons, no assaultive behavior, and pay on your payment plan.
Oh, Lord.
All right, sir. You're gonna have to stay at your mom's in Colon. Now, do you need a ride?
Yeah, could I get a ride there?
Yeah, when you get out of jail, come up here to the courthouse and they'll give you a bus pass.
For today?
Yes, courtesy of Mark and Sean and several others the Sheplers who've given me bus passes.
So,
All right,
where do I
sir.
go to get that? Where do I go?
Right
get
where
that?
the bailiffs, right at the bailiffs at the front there. Tell them Judge Middleton sent you.
Okay, right where I check in through the security place.
Okay, you're good to go.
Thank you so much.
All right, Keith, I'm not sure. I should have given him a small cash bond, but he's local. He's not gonna live there. All he did is take the phone away from her, throw it on the ground. All right. Thank you.
Yep. Anything else, let me know. I'm here.
All right, thanks.
All right. Well, we wait for the next contestant there. I'll go back to Judge Elmore, but I did pause this because I think somebody had a real tough night. Just judging from what I see on the screen, but let's find out.
Yeah, we're all, I said we're all going to try to figure it out. Yeah, okay. Just a minute. Sounds good. Thank you. All right, our next case this morning is People of the State of Michigan versus Jennifer Lee Williams. This is case number 25-14094 FH. Appearances from counsel.
Joanne here for the people.
And I'm Jeff Harrison. I'm here on behalf of Ms. Williams. As you may have already noted, she appears electronically from the Webster County Jail.
All right, thank you very much. Ms. Williams, are you able to see and hear the court this morning, ma'am?
Yes, sir.
Thank you. Ms. Williams, we are here today for an arraignment on a bench warrant. This court back on August 1st signed a bench warrant for your arrest. It was based upon an order that you had failed to enroll in drug testing as a term or condition of your probation. I'm sorry, of your bond or your pretrial release. One moment. Then additionally, we had a show cause for your failure to enroll in that program. And it looks like you failed to appear on that date, which was August 1st. Now, when someone fails to comply with the court order, it could be treated as a matter of contempt, for which a defendant could be sentenced up to 93 days and or $7,500 in fines and costs. The court recognizes before it also here in the back, Ms. Alex Matsky from the Western Missaukee Community Correction Program. So, Ms. Williams, we're not going to treat this as an issue of contempt. However, the court chooses to use it as a review of your pretrial release conditions, or in other words, your bond conditions. You have the right to challenge this allegation at a contested hearing and have the prosecutor prove the allegations, which could even be done right now if we so chose. At that, you'd hear some witness testimony. You could cross-examine that witness. You could also present witnesses' evidence or testimony if you chose to do so. And of course, you'll be represented by your defense attorney at that hearing. Again, the court must give you some due process. Now, if you're found to be in violation of your bond conditions could be modified, continued, or bond could be revoked and you could be remanded into custody. Now that I've told you what the allegations are, what your rights are, and the possible consequences of your choices, I'm going to turn to Mr. Harrison. Mr. Harrison, how's your client wish to respond at this time, sir?
At this point, Your Honor, we would, in light of the fact that she's also set to be arraigned on new charges, at 1:30 today, we have no option, frankly, but to do something to contest the bond violation at this juncture as well.
Okay. Well, we have a couple options there. Right now, we're at 9:50 a.m. We could proceed today and take testimony, or
I don't have my file. I didn't know she was gonna be arraigned up here today. I do have the new allegations,
all right.
but I was just
I
brought the
don't think
warrant.
it'll be terribly necessary to resolve this today, Your Honor, unless the court deems it so.
No, it's okay. I don't think the testimony is very complex. It might take all of 30 seconds, but the court will set it for a hearing.
I don't even have the sheet in front of me. I do have the new allegations. I just signed it.
That's okay. So is there another allegation that she test positive?
She had a pipe.
Oh, she had allegedly had a meth pipe. So that will also be dealt with at the hearing. Plus, I'm going to note that I'm concerned.
Right, okay.
I'm concerned with Ms. Williams' ability to comprehend what's going on, because it appears to me that she is under the influence of some substance based upon her demeanor and presentation today via Zoom.
And a similar concern was raised by jail staff this morning, so I feel more comfortable not proceeding today.
All right, thank you very much. Now, I did note that Ms. Williams appeared to make a comment. I did not hear that comment. I'm going to ignore it right now because she has counsel. Her counsel has spoken for her, and we will set it for a hearing. In the meantime, the court is going to deny the defendant bond and remand her into custody until the hearing. Thank you very much. We are adjourned.
Thank you.
All right. Our next case this morning is going to be people of the state of Michigan versus Jack Park. That will be file number 25-14081FH. Ottawa's outside of me, right? All right, good, thanks. Appearances, please.
Joanna Carey for the people.
Ma'am, please call Robert Champion appearing on behalf of Mr. Parks, who is standing to my left.
Thank you. You may be seated. We are here today for a final pretrial conference that was conducted a little while ago this morning in chambers between myself and counsel. Counsel informed me that we have a resolution that will result, that will involve a plea. Miss Carey, let's go with Miss Carey. Let's go ahead and tell them what the terms of the pretrial agreement are.
Thank you. As my understanding, the defendant would be there's no contest to an added count 2 use of meth as a second or subsequent offender, and the people will dismiss count 1 and the habitual offender 4th notice.
Thank you. Mr. Champion, is that a complete and accurate statement of the pretrial agreement, sir?
That is, Your Honor, and the reason for the no contest plea is there are pending litigation involving the same allegations in probation.
All right, thank you very much, Madam Court Reporter. If you could please give me a People's Exhibit sticker. Thank you. All right, Mr. Park, is that how you wish to resolve today's case, sir?
Yes, Your Honor.
Please raise your right hand to the best you can. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth, sir?
Yes, Your Honor.
Thank you. You may lower your hand. Now, I understand back on March 18th of this year, Mr. Park, you were on probation. Is that correct?
Correct.
And that was out of Missaukee County?
Correct.
Now, typically, at this point in time is where I would tell you that if you made any admissions, your admissions could be used against you in that other file. However, you're not going to make any admissions. I'm told that you're going to enter a plea of no contest. Is that correct?
Yes, Your Honor.
The court can accept no contest pleas in a couple situations. One, if there's civil liability. Two, the person was under the influence of some controlled substance or alcohol, or basically just can't remember. Or three, the interest of justice. And here I'm told that based upon your other, that you're facing a probation violation over in Missaukee County, we're going to use that as a justification for the no contest plea. Is that what you understood?
Yes, Your Honor.
A no contest plea is the same impact as a guilty plea. The difference is instead of requiring the defendant, you, to recite a factual basis to support the plea, I'm going to look at something else. And in this particular file, the parties have given me a copy of the police report. Do you understand?
Yes.
Now that means when it comes time to sentencing, you can't come back and say, well, that part of the report's wrong, that part of the report's wrong, and so forth. You understand? All right, thank you. Now, Mr. Park, you are currently charged on a felony information. Oh, hold on. Were you on probation or parole anywhere else?
No.
Were you on bond pending any felony charges anywhere else at that time?
No.
Thank you. Now, on this felony information, which is simply a charging document, you are charged with a single count. That count is possession of methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. Now, there are two sentencing enhancements that are also listed. One, within the discretion of the court, you can be sentenced as a second or subsequent drug offender. That could increase that potential punishment from up to 10 to up to 20 years, from up to $15,000 up to $30,000. Or in the alternative, you could be sentenced within the discretion of the court as a fourth habitual felony offender. That could increase that maximum punishment from up to 10 years up to life. However, all of that will be dismissed if you enter a plea of no contest to, and I accept that plea, and added count 2. Added count 2 would be for an offense of use of methamphetamine. Now that's a misdemeanor, generally punishable by up to a year and up to $1,000. However, you will also be pleading as a second or subsequent drug offender, which will increase that potential punishment from up to 2 years to, from up to 1 to up to 2 years, and from up to $1,000 to up to $2,000. Plus, of course, you can receive probation, and that would increase that misdemeanor up to a felony. Do you understand?
Yes, Your Honor.
So far, is that how you wish to continue?
Yes, Your Honor.
Now, by entering a plea of no contest, you'll not have a trial, and you'll be waiving certain rights that you would otherwise have at a trial. Does that make sense? Now, I'm holding up for you to see this piece of paper that the top says advice of rights. At the bottom, it appears to have your signature. Is that your signature?
Yes, I know.
Did you read through these rights before signing?
Yes, I do.
Did you understand what you read?
Yes, I do.
And again, even more importantly, do you understand that if you enter a plea of no contest, and I accept that plea, you will be forever waiving these rights as they apply to this case? Additionally, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements to force or compel you to plead guilty that we have not discussed?
No, Your Honor.
Are you entering the plea, sir, of your own free choice?
Yes.
Now, Mr. Champion has probably done a good job talking to you about sentencing. talking about how sentencing guidelines apply, how they are not mandatory, things like that, how they don't apply to misdemeanors, but might apply here. And also is probably try to give you his ideas to what he thinks I may sentence you to. The question that I have is, has he or anyone promised you or told you exactly what the sentence would be? Do you still wish to enter the plea as we discussed? As to added count 2, use of methamphetamine, how do you plead?
No contest, Your Honor.
All right, and before I go there, also, is it true that back on or about October 29th of 2020, now it doesn't tell me what you were convicted of, but you were convicted of another prior drug offense back then?
Yeah.
Okay. So before the court can accept your plea, I need to take a look at what I have been handed now as People's Exhibit number 1. People's Exhibit number 1 is a Michigan State Police Department Incident Report number 71-889-25. It consists of 3 pages and a couple supplements, as well as a Department of Science Division from Michigan State Police lab report. Ms. Carey, are you asking the people to accept, asking the court to accept People's Exhibit 1?
I am, for the record, we will amend or correct the felony information in the May 29th, 20.
October or something.
October.
Sure.
Sorry.
Should have been October 29th, 2020.
My records indicate that was possession of methamphetamine.
Does the defense so stipulate for the taking of the plea?
Yes, Your Honor.
Thank you.
Just,
Yeah,
I don't show in this criminal history in October. It does say May. But we'll file an amended.
either way, Mr. Champion, does the defense so stipulate that he has a prior drug conviction that can be used to enhance?
I do, Your Honor.
Thank you. Mr. Champion, does the defense stipulate to the admissibility of People's Exhibit number 1?
We do, Your Honor.
People's Proposed Exhibit number 1 for identification is hereby admitted. I have taken the opportunity prior to taking the bench this morning because I knew that this was going to be a plea. And I find that the report does reference the date as alleged on the felony information, which was March 18th of 2025. It gives a location that's consistent with the information that the events occurred in Herring Township here in Wexford County. The court does note that while there was a denial by Mr. Park to law enforcement officers that this substance was found in Mr. Park's vehicle, that the substance tested positive for methamphetamine, that the substance was in the driver's side front door pouch or pocket, that it was within his area of control. Therefore, it was he possessed the substance. Also, there is nothing here in the report that would show that the defendant had any lawful right to possess that substance. Ms. Carey, do you believe that there's a factual basis for in People's Exhibit number 1 to support the plea?
I do.
To the reduced charge? And I will note that it was in a syringe, which would also indicate use. Mr. Champion, do you agree?
I agree, Your Honor.
Ms. Carey, are you aware of any other promises, threats, inducement? How about you, Mr. Harris, Mr. Champion?
I'm aware of none, Your Honor.
Ms. Carey, do you leave the court's compliance with Scroll 6.302?
Yes, sir.
Mr. Champion?
I believe the court has, Your Honor.
And Ms. Carey, do you agree that the interests of justice do not require the defendant to recite a factual basis and the taking of a no contest plea is appropriate?
Yes, sir.
Mr. Champion?
I do also, Your Honor.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the information contained within the People's Exhibit number 1 supports a conviction for possession, but also a lesser charge of use based upon that it was in a syringe which is indicative of use. Therefore, the defendant is found guilty of add count 2, use of methamphetamine as a second or subsequent drug offender. Count 1 and the other enhancements will be dismissed at the time of sentencing. Mr. Park, as you may be aware, sentencings are done in this court on Monday mornings. I can predict that you'll be back here for sentencing in about 1 month from this coming Monday. Between now and then, you'll have to complete a packet of information that will be used to prepare a pre-sentence investigation report. An agent from the Department of Corrections, also known as the Probation and Parole Office, must prepare one of these reports anytime there's been a conviction in a circuit court, and especially when it's a felony. This report will describe the offense, pretrial agreement, criminal history, make a recommendation as a sentencing. Please keep in mind any guidelines, scorings, and recommendations are merely recommendations, as it is the court alone that determines the sentence within its authority. Once you complete this packet and turn it in, they'll set up an interview with you. You have the right to have your counsel present during that interview. And then third, Mr. Champion will meet with you generally about 2 weeks before we come back to go over that report. Each side has the right to make objections or request corrections to the report. Even if, and I assume that this is probably going to use your other PSI from the last case, even if there were any mistakes back then, I want to know about them so I can correct them so they don't continue to follow you and follow the files. You understand, sir?
Yes.
Mr. Park, do you have any questions about what we have done today, sir?
No.
All right. Bond continues to be revoked, remanded into the custody of the Missaukee County Sheriff Department. Mr. Park, I hope you're using maybe Miss Klotz over there. We're trying, I just had meetings yesterday with your board of commissioners, or other board of commissioners in West Missaukee, sorry. Trying to get more assistance inside the jail. So I hope that you're using the resources that we're able to provide. Trust me, I'm trying to get more in there. Thank you very much for your time. We are adjourned. Mr. Champion, you're.
So let's do this. I have a little bit from Judge Simpson a couple of hours ago. So let's go there.
Potential of a dismissal today. He's being held on bond denied because of the domestic violence case that was picked up. Given that the case has been dismissed, I would ask that the court consider reinstating his personal bond. He has been on a scram tether since January of this year. He's had no alcohol or drinking or tampering violations on that tether. He was just picked up on again, the domestic violence case. If the court is willing to release him today, he is asking the court to consider giving him a sober link. As I said, he did have no violations on the scram. He's been on it, well, been in custody for a few weeks now, but before that, no violations on the scram. He works with bikes, like literal pedal bikes. He runs both the
As opposed to what other kind?
Sometimes I think electric bikes. Yeah, there you go.
Motorcycles.
Yeah.
Sometimes people think motorcycles.
So he works at a place that sells bikes, and he also runs a nonprofit for children. So teaches young people how to ride bikes. So he's asking a sober link just because the scram can get in the way of pedaling.
Can get in the way of pedaling?
So I have more information if the court wants. So because he has tattoos on his legs, the device that detects.
No, you keep going because I don't know who's buying it, but go ahead.
The device that detects or tracks the skin has to be on clean skin, I guess, for lack of a better phrase. No, non-tattooed skin. And the only place that can be is the inside of his ankle.
Oh. Okay.
The chief will request the screen. He's done very well on it, and I want him to continue to do so.
They no longer have it on you, sir.
No.
No. All right. We are set for September 17th on this case.
Yes, Mr. Raggett is going to get a assessment done. I think we set it out that far. So if he were to be released, then he can get that done, get it to the people for consideration of a reduction.
What I will do is I will reinstate his previous bond. However, he has to be on a scram tether prior to release. I understand that he's done very well while on the scram. But I'd want that. I do recognize also that his blood alcohol was a 0.31. So a scram tether is justified in this case. All right. All right.
Thank you, Your Honor.
Thank you. You're gonna need this. Court does call the case of the people versus Keith Davis.
Ally's done on behalf of the people, Your Honor.
What? Okay. You know, I told you, leave that. They never listen. They never listen.
Judge, for the record, I'm listed on the multiple names, so it's not their fault.
I see.
It's not their fault. Good morning, Judge Simpson. Hugo Mack appearing with Mr. Davis. And just a record, I want to know my client's wearing long pants today. And
yes.
In recognition, the National Weather Service did cancel the flood warning. So
okay.
We're in good shape here.
Good shape. Your name, sir?
Keith Davis.
All right.
Your Honor, today's the date and time set for final settlement conference. At this time, the people are unable to proceed.
Your Honor, make a motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you so much, Judge.
All right, thank you.
Have a great day.
Thank you. Take care. Court does call the case, people versus Paris Calloway.
Conrad Silver on behalf of the township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Calloway. Mr. Calloway, please state your name for the record.
Good morning, Paris Calloway.
Thank you.
Your Honor, this is the date and time set for final settlement conference. People are unable to proceed. I did have a plea offer with Mr. Calloway as well on record that he's rejecting that plea offer.
All right.
Is that correct, Mr. Calloway?
Yes.
All right.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without.
Thank you, Your Honor.
Thank you.
Court calls case, people versus Maurice Cahey.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Cahey. Mr. Cahey, please state your name for the record.
Maurice Cahey.
Thank you.
This is the date and time set for final settlement conference. People are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right, thank you. Court calls case of the people versus Thomas Bennett.
Ally's done on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Bennett. Mr. Bennett, please state your name for the record.
Thomas Bennett.
Thank you.
Your Honor, today's the date and time set for final settlement conference. At this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Have a great day,
Thank
sir.
you.
Court calls the case, people versus Nicholas Bonsanek.
Ally's done on behalf of the people, Your Honor.
And Assistant Public Defender Natalie Pate on behalf of Mr. Bosnack, who should be present via Zoom.
Why is she?
Yes.
Oh, it's my Kiwi. Yeah.
Sorry, Assistant Public Defender Natalie Pate now with and on behalf of Mr. Bosnack. Mr. Bosnack, do you mind turning on your microphone and stating your name for the court if you can hear us?
Full name Nicholas Michael Bosonic III.
All right. Thank you, sir.
Your Honor,
Thank
today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. All right. Sir, thank you very much. Take care of yourself.
Thank you, Your Honor. Thank
And
you.
all those down in Kiwi land, eh?
Thank you very much.
Take care.
Thank you, sir.
You have a good day.
You too.
Bye-bye.
Court calls the case. People versus Jason Brooks.
Ally Zend on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brooks. State your name for the record, please, sir.
Jason Brooks.
And Your Honor, today's the date you have set final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you, sir. Thank you. Court calls the case of the people versus Shimona Byers. Yeah,
Ally Zend on behalf of the people, Your Honor.
I think it's Jay Jamoya. I give up.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Byers. State your name for the record, please.
Deja Moye, Byers.
Deja Moye.
Your Honor, today's the date you have set the final settlement conference. At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Court does call the case people versus Ashton Ebler.
Ally Zend on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with on behalf of Mr. Ebler, who is approaching. Please state your name for the record, sir.
Ashton Ebler.
Your Honor, today's the date you have set the final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, sir. Court calls the case of the people versus Marquand Gracie.
Ally Zend on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Gracie. Mr. Gracie, please state your name for the record.
Marquand Q. Gracie.
Thank you.
Your Honor, at this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you, sir.
Thank you.
Court calls the case people versus, is it Hishar Isa?
Ally Zend on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with on behalf of Mr.
Good morning, Your
Issa.
Honor.
Who stands to my right?
Good morning, sir. State your name.
Shar Issa.
Your Honor, today's date time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, sir.
Thank you, Your Honor.
Pretty much the same thing over and over, which often happens in Judge Simpson's court. Let's go back to Judge Elmore. He has a new contestant.
Robert Hartzell from Mr. Hack joins me to my left here.
Thank you. You may be seated. We're here today for a final pretrial conference that was conducted earlier in chambers between myself and counsel. I was informed that the parties had reached a pretrial agreement. Mr. Mirke, why don't you go ahead and tell me what that agreement is?
Thank you, Your Honor. And upon a successful plea and sentence to count one, failure to pay one's child support, and as a second felony offender, i.e. the habitual offender second, prosecution would dismiss count 2 and count 3, and the allegation that he is a third felony offender or each of third.
All right, thank you. Mr. Hartel, is that how you wish to resolve it?
It is, Your Honor.
Thank you. Mr. Hatt, how about you?
Yes.
All right. To the best that you can, sir, please raise your right hand. Mr. Hack, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. All right. Mr. Hatt, I'm looking back here on the alleged offense dates. Let's take a quick look here. Well, it's probably quite a date range. Woo. We got, looks like we're talking about back in 2000, from October 1st in 2021 through October 31st of 2022. Were you on probation or parole at that time?
No, Your Honor.
Now, you are currently charged in a felony information, which is simply a piece of paper with 3 counts. Each one of those counts allege a failure to pay child support. They cover different periods of time. They are each a felony punishable by up to 4 years and or up to $2,000. There's also a habitual offender sentencing enhancement. That is a 3rd habitual felony offender enhancement. That means that within the discretion of the court or the judge at the time of sentencing, if you were found guilty of those offenses, the maximum punishment could be increased from up to 4 years to up to 8, and from up to $2,000 to $4,000. However, I'm told today that you're going to plead guilty to count 1, which is a felony punishable by up to 4 years and $2,000. Then counts 2 and 3 will be dismissed. That 3rd habitual enhancement will also be dismissed, but you'll be pleading as a 2nd habitual felony offender. Now that has the result of increasing that potential punishment from up to 4 years to up to 6, and from up to $2,000 up to $3,000. Do you understand?
Yes, Your Honor.
Now, is that what you thought you were doing today, sir?
Yes, Your Honor.
Now, by entering a plea of guilty, you're not going to have a trial. Does that make sense, sir?
Yes, Your Honor.
By entering a plea of guilty, you're going to be waiving certain rights that you would otherwise have at a trial. But that includes the right to be tried by a jury, the right to be tried without a jury if you chose and the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have in defense to appear at the trial, the right to remain silent during that trial, the right to not have exhaust used against you, and the right to testify if you choose to testify. Sir, do you understand those rights?
Yes, Your Honor.
And even more importantly, do you understand that if you plead guilty, as we discussed earlier, you will be forever waiving those rights as they apply to this case?
Yes, Your Honor.
Additionally, any appeal as to conviction and sentence pursuant to the pretrial agreement would be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You will also be given up the right to claim the plea was the result of any promise, threat, or inducement not told to me today on the record. Other than the terms of the agreement, have there been any other promises, threats, duress, coercion, to force you to plead guilty that we haven't talked about? Are you entering the plea of your own free choice?
Yes, Your Honor.
Now, Mr. Hartel has probably talked to you about the Michigan sentencing guidelines and also try to give you an idea or estimate as to how those guidelines might score and to what he thinks the court may sentence you. The key question I have for you is, has he or anyone promised you what the sentence would be in this case?
No, Your Honor.
I highlight for you that the guidelines are a helpful tool given to the court by legislatures, or the legislature, but it is not mandatory. It is the court alone that determines the sentence. Do you still wish to enter the plea?
Yes, Your Honor.
As to count 1, failure to pay child support, how do you plead?
Guilty.
And do you also admit that previously back on or about December 16th, 2016, you were convicted of a home invasion second here in this courtroom in this county?
Yes, Your Honor.
So before the court can accept your plea, I need you to tell me what it is that you did that makes you guilty of this count. First, for this count, we're looking at the time period of October 1st, 2021 through October 31st, 2022. Here in the city of Cadillac and Wexford County. And did you have a child that lived over here?
Yeah.
And what was that child's name, first name?
I think it's Alexis.
You don't know which one it involves?
I mean, I do know which kid, but I don't really know the child. I haven't been part of her life.
But is it true you had a child that you had over here and the courts over here ordered you to pay child support for that child?
Yes, Your Honor.
And you were required to pay that child support for that child back between those dates that I gave you earlier. Is that right?
Yes, Your Honor.
And is it true that you failed to make those payments as directed by the court?
Yes, Your Honor.
Thank you. Mr. Miracay, do you believe the defendant provided a factual basis?
I do, Your Honor.
Are you aware of any other promises, threats, inducements?
No, Your Honor.
Do you believe the court's in compliance with Parole 6.302?
I do, Your Honor.
Thank you. Mr. Hartel, do you agree?
I do agree, Your Honor.
Thank you very much. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements. Therefore, the defendant is found guilty of count 1. Counts 2 and 3 will be dismissed at the time of sentencing. A third habitual offender will be dismissed at the time of sentencing, but the defendant is found to be qualify as a second habitual felony offender. Mr. Hatt, the case will now be set for sentencing. Sentencings typically take place in about 4 weeks, and they're done on every Monday morning in this courtroom. Between now and then, an agent from the Michigan Department of Corrections will prepare a pre-sentence investigation report. One of these reports must be prepared anytime someone's convicted of a felony in a court in the state of Michigan. There are 3 steps that involve you. 1, you're going to get a packet, and I see that has already been provided to the bailiff. You're going to complete it and turn it in. Number 2, there'll be an interview with you by an agent from the Department of Corrections. You have the right to have your counsel present during that interview. And number 3, Mr. Hartel will bring that report to you prior to coming back to sentencing, and you guys will go over it together. Now, it's really important that you pay attention to it. We want to make sure that it's complete and accurate before I give a sentence based upon that information. Do you understand? Do you have any questions, Mr. Hatt, about what we have done today? Anything further from you, Mr. Miracay?
No, Your Honor.
How about you, Mr. Hartel?
No, Your Honor.
Thank you. Mr. Hatt, we will see you in about a month. Thank you. We're adjourned.
Continuing on.
Court revokes bond. Thank you. All right, our next file is going to be People of the State of Michigan versus Joseph Magnet. This is case number 25-14054 FH. Appearances, please.
Robert Miracay, Special Assistant to the Attorney General on behalf of the people, Your Honor.
Robert herself and Mr. Magnet, who joins me at the table, Your Honor.
Thank you. We're here today for a final pretrial conference. I conducted it earlier in chambers with counsel. Counsel informed me that they anticipate a resolution today. Mr. Miracay, why don't you go ahead and tell me what the terms of the pretrial agreement are?
Thank you, Your Honor. It's rather lengthy and convoluted, but I'll try my best.
Good luck.
Because the defendant has reduced his arrears to less than $18,500, the prosecution is willing to make the following offer. That upon a successful plea to count 1, failure to pay one's child support, the state will dismiss count 2, it will dismiss count 3, and furthermore, it will make a recommendation to the court that the defendant receive a delay of sentence at the time of sentencing, which is my understanding within about a month's time. Furthermore, there will be some inducements with which the defendant may make the situation better, and that if during the delay of sentence or earlier, he reduces the arrears to $12,500 or less, we would ask the court to enter a conviction to attempted failure to pay child support. And if the defendant is able to reduce his arrears to 0 prior to the conclusion of the delay of sentence period or earlier, the prosecution would ask the court to amend the conviction to a disorderly person, a 93-day history.
Mr. Hartel?
That is accurate, Your Honor.
All right, Mr. Magnet, is that how you wish to resolve it?
Yes, sir.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth, sir?
Yes, sir.
You may lower your hand. All right, Mr. Magnet, I've been told that you don't have any prior criminal history. Is that correct?
No, sir.
So that means during these periods of time that you allegedly owed child support, you weren't on probation or parole.
No, sir.
Now, you are currently charged on a felony information with 3 counts. Each count is a charge of failure to pay child support. They cover each a different range in time. Each of them are a felony punishable by up to 4 years and or up to $2,000. I'm told today that you're gonna plead guilty to count 1. If you do, and the court accepts that plea, then there are other things that will follow. First, the prosecution agrees to dismiss counts 2 and 3. Next, it agrees to recommend, and I'm going to talk about that word recommend, to recommend that at sentencing you be placed upon a delay of sentence. A delay of sentence can last up to 1 year. And the reason for a delay is to permit you the opportunity to demonstrate that you should receive a benefit that the prosecution agrees to. Now, that delay is within the discretion of the court. It can only last up to 12 months. The conditions of that delay that the prosecution agrees to is if at the end of that delay or sooner, at least by the end, if you reduce the arrears that you owe for all three dates from or down to $12,500 or less, then you'll be able to withdraw your plea to the felony of 4 years, enter a plea to an attempt to fail to pay his child support, which is still a felony, but punishable by up to 2 years and or $2,000. Then, if you reduce your arrears all the way down to 0, then the people agree that they would support you to be able to withdraw your plea and then enter a plea of guilty to disorderly person. Now, this disorderly conduct has kind of got a little catch-all. It's got if you're jostling or bumping people in a crowd, drunk and obnoxious, but also failing to take care of a child. That would be a misdemeanor punishable by up to 93 days and or up to $500 in fines. So I feel like I should turn around. There should be snow falling outside. Anyways, we're gonna go back on. Do you understand that's what the agreement is between you and the prosecutor?
Yes, sir.
Now, when we come to agreements about sentencing, there are, normally I talk about 2. There's really 3. And there are 3 words here. 1, it's called COB. 2, we call it kilogram. 3, we call it recommendation. Now, a COBS agreement, I don't do. But a COBS agreement, which is based upon the name of an appellate case, says it's an agreement that is like a triangle. You and the prosecutor, and I agree right now, here's what's going to happen at sentencing. I don't do those because I never know who the person is. You might be wanted all over the world, but we just don't know it yet. I'm told that you're not, and I'm told that you don't have any prior convictions, but sometimes, I know this might surprise you, sometimes the person sitting in your seat lies to the person sitting next to him and or the prosecutor and or me. I'm not saying you are, but that's why I don't do them, so we don't waste time. Now, a kilogram agreement isn't a triangle, it's a line between you and the prosecutor. And then at the time of sentencing, if I don't go along with it, you automatically have the right to withdraw your plea. So far, this plea agreement isn't a triangle called the COBS. It isn't a line that's binding called a kilogram. It's the third type, a recommendation. Recommendation is not binding at all. Now, Mr. Hartel, who practices here in front of me every week, and also over in Missaukee County on occasion, probably has a pretty good idea what I'm going to do and look at and think. Now, if you don't have any issues in criminal history, which means you've never been on probation, which means you've never had probation violations, things are probably going to go pretty well. Now, if that check bounces, because I've been told you made a big payment today, if it's rubber, then you're probably not going to get the benefit. Okay. Oh, great. So cash doesn't bounce. Cash is good. And cash is king. We all love cash. Not that too many people handle it anymore. They handle plastic. But anyways, So I don't know, but that's the recommendation. Mr. Hartel can give you advice and I trust that he has. You understand?
Yes, sir.
Now, if I enter a plea of guilty today, if I accept that plea, you're not going to have a trial. Does that make sense? By entering a plea of guilty, you're going to be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, and the court or prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question or cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at trial, the right to remain silent, the right to not have a silence used against you, and the right to testify at the trial if you chose to testify. Do you understand?
Yes, sir.
Now, additionally, any appeal as to the conviction and sentence will be by filing an application for leave to appeal and not an automatic or claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, you'll be given up the right to claim the plea was a result of some promise, threat, coercion, duress. You don't tell me about. Have there been anything else other than the terms of the agreement to force you or compel you to plead guilty? Are you entering the plea of your own free choice? Has Mr. Hartel promised you anything as to how I'm going to sentence you? All right, good enough. You still wish to enter the plea of guilty?
Yes, sir.
All right, good. As to count one, failure to pay child support, how do you plead? Before the court can accept that plea, I need you to tell me what you did that makes you guilty of offense. Now, talking about a date range between March 1st of 2021 and May 31st, 2021. Did you have a child that was alive at the time? And during that period of time, were you required by some court order to pay child support?
No.
And is it true that you failed to pay that child support during that period of time?
Yes, sir.
All right. Mr. Miracade, do you believe he's provided on a factual basis?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's in compliance with the court rules?
I do, Your Honor.
Mr. Hartel, how about you? Do you agree?
I agree.
The court agrees and finds that defense plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for count one. Therefore, the defendant is found guilty of count one. Counts 2 and 3 will be set for sentencing. I'm sorry, will be dismissed. Still going too fast. All right, so we'll be back here for sentencing on count one in about 4 weeks from this coming Monday. Between now and then, an agent from the Department of Corrections, also known as a probation or parole office, will prepare a pre-sentence investigation report. That report will tell me about you, tell me about your employment history, criminal history, if any, and we'll make a recommendation as a sentence. That recommendation is merely that, a recommendation. Remember, recommendation means not binding. I'm the one that makes it set. I'm the one that determines the sentence. You're going to do you've got 3 tasks that involve you in the preparation of this report. When you leave the courtroom, you can take the elevator, and I might judge you because I think everybody should use the steps if you can.
Yes, sir.
But you can take the steps all the way down to the bottom. When you step out, you're going to do a button hook to the right, go down that hallway, walk through the door, go down that hallway, last door on the left. You can't miss it. So steps or elevator all the way down, sharp button hook to the right, through the doors. They're going to give you a packet. You're going to complete it, turn it in. Or also we'll schedule an interview with you. You have the right to have your attorney present during that interview. And your attorney will meet with you generally about 10 days or 2 weeks before coming back here to court. And you guys will go over that report. You want to make sure it's complete and accurate before I give a sentence, because each side has the right to come here, make objections, request corrections to the report. Now, you especially want to make sure that it's all complete and accurate, because if it says, lo and behold, you are wanted all over the world and you do have lots of criminal convictions, and that's not true, you want to correct it, because getting the benefit of your recommendation agreement with the prosecution is really important, okay? I also cannot stress enough, make sure you're still compliant with your terms and conditions of bond. You don't want to get picked up on new charges. Now, I have no reason to think that you will, so please do not be offended. Right? I just want to highlight it for you, so when you leave, you don't come back and go, well, geez, Judge, I wish you would have warned me. I warn you. So, but again, I don't have any reason to think that you're gonna mess it up. Do you have any questions for me today, Mr. Magnan?
No, sir.
How about anything else, Mr. Hartel? And any objection to continuation of bond?
No, Your Honor.
The bond hereby continues. You are free to leave the courtroom, but don't forget your exercise down the steps and your sharp button hook to the right. Carry on.
Thank you, sir.
We're adjourned. Thank you, Mr. Beard.
Okay, friends, this is the logical place to leave it for today, a couple of minutes early, but it doesn't make any sense to take on another hearing. I want to thank all of you today for your generosity, first and foremost. It's very much appreciated. And the interaction we had in the chat today, we learned some stuff, we talked some things out, we saw some good court, just a really good Friday, and I really appreciate all of you for participating in it, and I hope you had as much fun as I did. I absolutely love what we have here, and I love waking up every day to be able to go live with you guys, and it's just a joy, so thank you so much. It's so much a joy that we'll be back tomorrow night, 8 p.m. Eastern, 5 p.m. Pacific for game night. I'm 90% certain we're going to do a Lego game, probably Lego Star Wars, but I'll announce it officially probably a little later today. So if you can, tune in for that. We started that last week, and it was a lot of fun. And I actually didn't play as bad as I thought I would, so because it's been a long time since I've really picked up the controller, so it was good. But I hope to see y'all there. And then, of course, we'll be back on Monday, 10 a.m. Eastern, 7 a.m. Pacific for this show, a half an hour early for channel members. Again, appreciate you so much. Go have yourselves a good weekend. Hopefully, we'll see you tomorrow evening. In the meantime, take care. God bless.